Leave. Hey, everybody. Welcome to the Law of Self-Defense. Hopefully we're live. Let me see if I can check on my end. We should be ready to go. And there we are. Awesome. So welcome, everybody, to the Law of Self-Defense show. Obviously, we still working out how to work all this technology to give you the best possible service in these shows, but I think we're making progress. I also need to check and see if it looks like I may have to do another slight adjustment here. Hold on just a moment, folks. Make yourselves comfortable while I take care of all this tech stuff. Let's see. Well, it says it's live. It's live. But unfortunately, it does not appear to be working quite right. We're trying to stream this also. Stream this. Oh, maybe it is working. Let me see. Oh, it is working. Good heavens. All right. So good news for all you Law Self-Defense members. We are now able to stream these shows directly to your membership dashboard. And of course, we will prioritize the questions we receive from our members above all others. As usual, if you're watching this on YouTube, we'll also answer your questions that were sent in by Super Chat. There's way too many to answer every possible question. Sorry, folks. So we prioritize the Super Chat questions. And today's show, of course, is about self-defense immunity. Let's adjust that a little bit. We had a case brought to our attention by an attorney, friend of ours down in the state of Florida, of a successful self-defense immunity argument made this past Friday in Florida. There was a very well-written motion by the judge in that self-defense immunity hearing, dismissing the charges against the defendant and granting immunity from criminal prosecution and civil suit. And this defendant was looking at 20 years in prison. In fact, they'd already been convicted once at trial and sentenced to 20 years. They were serving a 20-year sentence when they appealed their conviction and got it reversed on the grounds of ineffective assistance of counsel, which is perhaps the most common grounds for appeal from a criminal conviction, and it's almost never, ever successful. How poorly an attorney has to conduct themselves in a criminal trial to be deemed ineffective at a constitutional level is unbelievable. So it's such a low standard that virtually every criminal defense attorney, no matter how bad they are, you can be a bad attorney and still not be constitutionally ineffective. This particular attorney in this defendant's first trial was found by the appellate courts to be, or to have been, ineffective counsel, failing this defendant's constitutional right to legal counsel, and therefore his conviction was overturned. Now, when your conviction is overturned, generally it doesn't mean the appellate court's not finding you not guilty. The appellate court's basically saying there was a legal error in your first trial sufficient to reverse that finding of guilt, and we're going to give you a second trial. And unfortunately for many defendants, you don't have any more resources for the second trial than you did for the first. Generally, you have no resources left for a second trial because how much money did you spend in your first trial in order to not have to spend 20 years in jail? Probably everything you could get your hands on, everything you could beg, borrow, and steal is what you spent on your criminal defense for your first trial. So if you get convicted and then that conviction is reversed, which is good news, obviously, or you go through that first trial and it's a hung jury, it's a mistrial. In any case, they decide to subject you to a second trial. Generally, you have no resources left for that second trial. Very common, in my experience, to see defendants have very high-powered, expensive legal counsel in their first trial, somehow end up with a second trial and have a public defender for the second trial because they're literally impoverished from the first trial to the point that they now qualify for a public defender. So this defendant's coming up gets a shot, a second bite at the apple. He's going to get a second trial, but this is in Florida, and Florida is one of the many states that allows for self-defense immunity. And so he decided to seek a self-defense immunity hearing prior to his second trial, and that's where all of this comes out of. By the way, folks, when I talk about being impoverished by the costs of these criminal trials, if you've killed someone in self-defense, and you're facing a killing charge, a manslaughter or murder charge at trial, it's very easy to go through $200,000 before you even get to trial, just in pretrial expense. And then just add on the cost of the trial upon that. If you haven't killed anyone, you may not even have hurt anybody. You drew your gun, you presented it in what you believe is self-defense. You presented your gun for the purpose of changing someone else's behavior, which is what we do in self-defense, right? Stop, I have a gun. Well, that also checks all the boxes for aggravated assault with a firearm, which can be good for 10 to 20 years in prison all by itself. So that's not a killing charge, but nevertheless a very serious felony charge with a very lengthy sentence if you are convicted on that charge. And you'll find in most parts of the United States that your lead counsel wants a retainer of $30,000 to $50,000 to represent you. And that's for pretrial work, folks. That's not to cover the cost of the trial. That's to cover the process of getting up to hopefully what will be a dismissal of the charges. If you need to go to trial, the cost will be substantially more than that initial 30 to 50 grand. Which brings us to the sponsor of today's show, which is, as usual, CCW Safe. They're a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, they promise to pay their members' legal expenses if the member is involved in a use of force event. And as I just explained, those expenses start big and get bigger fast, folks. So if you don't have that kind of money stuffed in your mattress, just in case you're compelled to defend yourself against criminal predation, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you'd want it fought, as if the rest of your life depends on it, because really it does. And that's what CCW Safe does. Now, there are a number of companies out there that purport to offer similar services. I've looked at all of them, as you might imagine. I found that for me personally, CCW Safe is by far the best fit. I'm a member of CCW Safe. My wife is a member of CCW Safe. One of the reasons for that, by the way, is because they cover you not just for the trial, but in the event you end up with a second trial, a retrial, they cover that. If you appeal your conviction, they cover that. If you have a mistrial, there's no conviction, but the prosecutor decides to try you again, which is their privilege. In the case of a mistrial, they cover that without limitation. So just one of the reasons I'm a big fan of CCW Safe. Whether they're the best fit for you, as they are for me, is something only you can decide, but I do encourage you to take a look at what they have to offer. You can do that at lawofselfdefense.com/CCWSafe. And if you do decide to become a member with them, you can save 10% off your membership at that URL, lawofselfdefense.com/CCWSafe, with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Okay, so that's enough about the wonderful sponsor, CCW Safe. Let's see where we can get to now. So this self-defense immunity hearing, again, was brought to my attention by a lawyer friend of mine in Florida. He prefers that I not name him, which is fine. I asked, offered to give him a tip of the hat, but he preferred not, at least at the moment. But he brought this motion to my attention. Let me see if I can pull this up for all of you. And this is what we're going to step through today. See if I can do this appropriately. Share this with all of you. Share screen. And I don't know why it's showing blank like that. Hold on, folks. Try this again. Surely there must be a better way. Oh, technology. So, all right. Well, that shows up for me. But this does not. All right. Just give me just a moment, folks, because I really do need to be able to share this with all of you. So let me see if I can figure out a way to do this so that it's shareable. This is the order of dismissal from the court. And the whole point of today really is to step us through this. So maybe I need to upload it to the internet, and that would make it shareable. Uploading. Make it full screen. All right, this might work. Whoops. How's that? All right. Well, except it's static for all of you. It's not scrolling like my screen is scrolling. Oh, that's not great. Good Lord. Okay, try it again. Let's see. Maybe if I just share the tab, maybe that'll work better. Yep, that does work better. Okay, so I think I worked that out. So here's the order. State of Florida v. Boyd Jean Wiley. And this is really a well-prepared, well-written order of dismissal by this judge. The judge's name is Howard O. McGillen Jr. He's a West Point grad, former JAG officer, meaning Judicial Advocate General's officer in the military, the military lawyers. And now he's a judge down in Florida. And the attorney involved for the defense was John Terhune. I apologize if I'm not pronouncing that correctly, John Terhune, a public defender down in Florida representing this client. Again, I don't know if the defendant here, Mr. Wiley, had private retained counsel for his first trial in which he got convicted, but he has a public defender at this point in the process. Again, perhaps because of the catastrophic financial cost of that first trial. So we have a great order to dismiss here. Very well structured, very well written. They're not always well written, folks. There's some really bad ones out there. We'll see one of those shortly, by the way. So next week, we'll be covering the trial of Curtis Reeves. Curtis Reeves is the Florida movie theater popcorn shooter. He shot and killed Chad Olson in a Florida movie theater after they argued about Chad texting before the movie started. Apparently, Chad threw some popcorn at Mr. Reeves. Mr. Reeves, a retired SWAT captain, accompanying his wife to see a movie, then pulled his pistol, concealed carry pistol, shot Chad Olson once in the chest, fatally wounding him. Chad was there with his own wife, so Chad would die in his wife's arms there in the movie theater. This all happened in 2014. We're only getting to the trial now, which is 8 years later, which is remarkable. The defendant here, Curtis Reeves, is elderly, doesn't look in great health. For many years, I'd begun to suspect that maybe the authorities in Florida simply wanted to kind of time this out and delay the trial long enough that Curtis Reeves would simply die of old age and they wouldn't have to bring him to trial, but he didn't. So here we are. His trial finally starts this Monday. We'll be covering that in detail. And one of the elements of that case is Mr. Reeves had himself applied for self-defense immunity, had a self-defense immunity hearing under Florida law, was denied immunity by that trial judge. And that self-defense immunity order was horribly written, lots of mistakes of law in it. So we'll be covering that in the future when we cover the Curtis Reeves trial. This order to dismiss and this stand your ground hearing was very, very well done, very well structured. So it has major components. We'll be stepping through each of these. First, the first section of this order is the procedural posture, meaning how did we get here? Where did this case come from that we find ourselves at this point in this self-defense immunity hearing? So it'll talk about the past trials and various procedural aspects. Then we have the second major section, which is the legal standard applicable. This is essentially asking, how do we get to an answer here? What's the algorithm? What's the calculation that's required for us to perform? The machine into which we'll put the facts. The next major section of this order is the facts. What are the inputs from the algorithm? And frankly, folks, the best way to think about a self-defense immunity hearing is as a mini trial. It's an adversarial process. So there's arguments for and against self-defense immunity, really meaning for and against self-defense. The state is present and they're arguing against self-defense naturally. And of course, the defense is present and arguing for self-defense. Unlike an actual trial, there is no jury. So the judge in the self-defense immunity hearing plays the roles of both judge, finder of law, determiner of law, and the finder of fact. So he hears the adversarial argument between the two parties. He decides what facts he believes are true, are credible. And those are the facts he puts into the legal standard machine, the algorithm, cranks the handle, and comes out with ultimately his conclusions of fact and law. In this case, of course, it was that the use of force was self-defense, or at least the state had not met its burden to disprove self-defense, and therefore self-defense immunity was granted to this defendant. So instead of going into another hugely costly, risky trial, facing the prospect of another conviction, another sentence of 20 years in prison, this defendant was told to go home. And without any possibility of further prosecution of him or civil suit against him, which otherwise would also have been on the table. So we're going to step through each of those sections. The best way to think of conceptually these self-defense immunity hearings are really as a mini trial, an accelerated, relatively low-cost way of arriving at a finding of self-defense or not, without having to go through the tremendous time and cost and risk of a trial. Self-defense immunity hearings are not risky, folks. Well, I'll caveat that in a moment. You can't get convicted in a self-defense immunity hearing. Obviously, you can at trial. So you don't have the risk of conviction in the self-defense immunity hearing. The worst that can happen is from a legal outcome perspective, is that the hearing judge, who's also going to be the same person as the trial judge if you go on to trial, but the hearing judge might deny your claim of self-defense immunity hearing, in which case you simply go to trial like you would have otherwise, or he'll grant your request for self-defense immunity, in which case it's all over. The process stops right there. It didn't take hundreds of thousands of dollars in legal expenses, took maybe a few $1,000s. It didn't take years to come to trial. Again, the Curtis Reeves case I just mentioned, that happened 8 years ago, that shooting, and it's only coming to trial now. So Curtis Reeves had that hanging over his head, the prospect of a murder conviction and life in prison for the last 8 years. Now, he's older, but imagine if you were, I don't know, 25 or 30 years old, and for 8 years you had the possibility of life in prison hanging over your head. Wouldn't that freeze your life? I mean, what do you go to college? Do you get married? Do you have kids? That's a long period of time to have your life on hold. So I'm a big fan of these self-defense immunity hearings because they are an accelerated way to get to this determination of self-defense. Now, I mentioned earlier there's no risk in these hearings, and what I mean by that is if you lose, you just go to trial, which is where you were going anyway if you didn't have the hearing. There is some risk, however, and many attorneys I know in Florida in particular, but this would be true in any jurisdiction with self-defense immunity, they're sometimes hesitant to request a self-defense immunity hearing on behalf of their client because, again, that's an adversarial process. Arguments on both sides are made. So the prosecution is going to hear the defense argument for self-defense, and they're going to hear the defense attacks on the state's narrative of guilt, narrative of not self-defense. So it gives the opportunity for the prosecution to see the defense's playbook, so to speak, without the before they have to go to trial. And therefore, the prosecution might fine-tune their narrative of guilt with this insight into the defense narrative of self-defense, and make the defense more difficult once they get to trial. So some defense attorneys are hesitant to expose to the prosecution their playbook, so to speak, before they go to trial, and therefore they don't request the self-defense immunity hearing. And of course, that's influenced in part by the degree to which you think you're likely to get self-defense immunity. If you don't believe you're likely to have a grant of self-defense immunity, either because the judge appears disinclined, or it's a politically energized case, or a racially energized case, or there are drivers against granting self-defense immunity, even where that would be the right legal outcome. Well, if you don't think you're going to get the grant of self-defense immunity, there's no point then to have the hearing, especially when having the hearing requires you to basically expose your game plan to the prosecution before trial. So arguably that is a form of risk in terms of having the hearing as opposed to going straight to trial and making your self-defense argument there. Now, it is true that the legal standard for having been found to have acted in self-defense is much lower at trial. So it's in that sense, it's an easier threshold. Self-defense is an easier threshold at trial than it is at the self-defense immunity hearing. So you might go to the self-defense immunity hearing, lose there. That doesn't mean you're going to lose a trial, because the threshold you need to get that pre-trial grant of immunity is much higher than the threshold you need for self-defense at trial itself. We'll talk about that as we talk through the legal standards in this motion. So, oh, good. So for those of you who are law self-defense members, it is accurately streaming on your member dashboard, and I see people are commenting. Hey, Oscar, good to see you. D, very nice to see you. And we will be prioritizing law self-defense questions that are submitted during the show. So if you're a law self-defense member and you're watching this on YouTube, feel free to stay, but you might also want to consider clicking over to your member dashboard, putting your questions there, because we'll certainly answer all of those. So let me do a quick scroll through the comments right now. It doesn't look like any substantive questions yet, which is good. We haven't gotten to much substantive. By the way, you see on the screen there, by just next to my tie, lawofselfdefense.com/gethard. That's for the hardcover version of our best-selling book, The Law of Self-Defense, The Indispensable Guide to the Armed Citizen. You can get that at lawofselfdefense.com/gethard. And that reminds me, actually, there's a funny aspect of this self-defense immunity hearing having been brought to my attention. So I mentioned my lawyer friend in Florida told me about this. I reached out to John Terhune, who was the public defender in this case, who won self-defense immunity for his client. I was introduced to John by my friend in Florida. My friend essentially told John, hey, there's this guy, Andrew Branca at Law of Self-Defense. He specializes in use of force law. Maybe you should talk with him about your self-defense immunity win here. And John Terhune's answer was, oh, yeah, I know Andrew. In fact, I have a copy of his book, The Law of Self-Defense, sitting on the case file for this case. And that's John's case file for this defendant, Boyd Wiley. And there's The Law of Self-Defense sitting right there. So John was already familiar with me, I guess, by reputation and by work product. By the way, John has agreed to be interviewed for the law of self-defense community about this self-defense immunity hearing, which is very generous of him. He, of course, does not have to do that. There's no benefit to him to doing this interview, but it would really give us, that inside baseball perspective of how this all worked, in a sense far greater than we can get from the judge's order to dismiss. And we'd originally scheduled that interview for this Friday, which was amazing for John to agree to come on board for the interview that quickly. Unfortunately, John's boss at the public defender's office quite reasonably said, hey, listen, the state technically has a certain period of time to appeal this grant of immunity. I'm unclear if it's 2 weeks or 30 days, but it's some window of time in which the state could appeal. We wouldn't want to put out an interview that the state may feel gives it grounds for an appeal of this immunity grant. So John's decided to wait out that time period for appeal by the state of this grant of self-defense immunity, and then do the interview with us after that. So in 2 weeks or in 30 days, whichever the standard is, John will find out. We will have Attorney John Terhune on the show here as a guest to give us his share with us his experience and insight into self-defense immunity generally, and in this case in particular. So very grateful to John for being willing to do that. So with that, I think we'll jump into the motion itself. Let me see if I can pull this up again. And there we go. So this is an order on motion to dismiss. So the way this works is the defendant here, Boyd Wiley, is facing trial. We're still in the pre-trial phase, so there's no jury selected yet. And that's not scrolling again now. Very interesting why this is being so uncooperative. Does it just take time? Very, very annoying. I thought I had it working. Oh, I remember now. Here we go. All right. So here we have this order to dismiss. So again, this happens pre-trial, so there's no jury selected yet. The participants are the prosecution, the defense, of course, in the form of public defender, John Terhune and his client, Boyd Wiley, and the judge in this case, whose name is Judge Howard O. McGillen. Now, this junior, this will be also the trial judge. So this is one of many pre-trial hearings, preliminary hearings, they're often called, which makes them sound unimportant. How important can a preliminary hearing be? It's preliminary. But often these hearings determine the outcome of the trial all by themselves, because they're defining the legal battlefield of the trial. They're defining what legal arguments can be made. They're defining what evidence will be admissible or not admissible in court. And those factors by themselves can effectively determine whether or not the verdict's likely to be guilty or not guilty. So they're really, really important, these pretrial hearings. In this case, of course, this particular pretrial hearing, the self-defense immunity hearing, has the potential to make the entire legal peril go away, disappear, by granting immunity against criminal prosecution and civil suit. So Florida self-defense immunity law covers both criminal and civil liability. Other states do things differently. Some states have only civil immunity, some have only criminal immunity, some have neither, some have both, but Florida provides for both. So this is a hearing that can make everything go away for this defendant. And again, it's going to be like a mini trial. So there won't be a jury. The judge here, the hearing judge, plays the role of the judge, the finder of law, the determiner of how the law is supposed to be applied, what the legal standards are, what the legal thresholds are, and so forth, what the legal algorithm is. And he's also the finder of facts. So he determines what facts are put into the machine, which are then processed by the algorithm to come out with a verdict, a finding of immunity or not immunity at the end of the process. So we're going to talk about all that. We're going to talk about how we got here. We're going to talk about what the legal algorithm is, what the legal standards is, how the decision is supposed to be made. Then we're going to talk about the facts, and the judge will hear both sides, the state's narrative of not self-defense and the defense narrative of self-defense, decide which facts he believes are credible and proven, and then insert those facts into the legal algorithm, crank the handle, and come out with a finding of whether or not immunity ought to be granted in this case. So let's go. We'll step through this. I'll see if I can, am I able to highlight? Not great, unfortunately. So this cause, as it starts, came before the court January 13th, so that's when the hearing would have occurred. So we actually got a pretty quick decision on this, because the decision came down January 28th. Now, the I don't remember what day of the month the 13th was, but the 28th was just last Friday. 13th would have been 2 weeks roughly prior to that. So in just 2 weeks, he had the hearing and got this finding of self-defense immunity from the judge, and all his legal peril went away without the cost, time, and risk of a full-blown trial. So that's remarkably efficient for any government apparatus. Of course, the case involves the state of Florida and the defendant, Boyd Jean Wiley, who was represented by attorney John Terhune. John obviously did a fantastic job here. John is a public defender. And again, I'd like to reiterate that many people have the perception of public defenders as somehow being second tier or third tier lawyers. That's not at all the experience professionally that I have. In fact, my first real exposure in the law, participation in the criminal justice system, was working for a public defender's office in upstate New York. I wasn't a lawyer then. I was working as an investigator for that office, but that's before I went to law school. But I've had the opportunity to meet, since the very start of my legal career, meet and work with many, many public defenders, and many of them are world-class attorneys. What is generally true, or often true, is that they're often very, very overworked. So they may have dozens and dozens of cases that they're dealing with at one time, whereas if you hire a private criminal defense attorney, you get a much larger fraction of his attention, maybe 100% of his attention, as opposed to him having to juggle tons of other cases as well. So don't assume that public defenders don't know what they're doing. Often they really, really know what they're doing, and obviously John is an example of one of those who clearly is a master of his craft. So the court heard testimony of witnesses, observing their demeanor and evaluating their demeanor, so making decisions of credibility, things that a jury would normally do in place of a judge if this was a trial. They considered the evidence of the record, reviewing the file, so things that have been argued prior to this hearing. I remember this defendant had a first trial in which he was convicted, found guilty, and sentenced to 20 years in prison. So he was serving that 20-year prison sentence when his first conviction was overturned because of ineffective assistance to counsel. So now he's lined up for a second trial, and he's requested this self-defense immunity hearing in preparation or prior to that second trial. So how's that done? Is this case comes before the court on a motion to dismiss based on immunity under Florida Statute 776012. So this document, this motion, for those of you who are law self-defense members, the version of this content that you're watching right now that we put on our membership dashboard, our membership site, the membership blog, will include all these documents. So it'll include this motion. It'll include links to all the relevant statutes. So that's one of the benefits of accessing this content as a member. So what the court's referring to here, 776012, is really Florida's self-defense statute. I'll pop that up in just a moment. And here it says, known more colloquially as Florida's stand your ground law. Now, this is a pet peeve of mine. It's not really Florida stand your ground law. There is no stand your ground law. What happened is, years ago, Florida decided to become a stand your ground state, meaning relieving otherwise lawful acts of self-defense from a legal duty to retreat before people can defend themselves. Obviously, this became very high profile during the George Zimmerman trial, even though the Zimmerman trial had nothing to do with issues of retreat or stand your ground. But when Florida adopted this stand your ground language, it wasn't a separate statute. They just added language to their existing self-defense statute, which was and remains Statute 776012, as we see here. So there is no separate stand your ground, no duty to retreat statute. They just added words to the effect of you have no duty to retreat to their various justified use of force statutes. So defense of yourself, defense of others, defense of property. And we'll see that as we step through the statute. So there's not really a stand your ground law per se. There is a independent statute for self-defense immunity. That's statute 776032. We'll cover that as well. So that is a stand your ground statute, but it has nothing to do with stand your ground. It has nothing to do with whether or not you have a legal duty to retreat. It has nothing to do with the elements of self-defense, really. It merely says that if you meet the elements of self-defense, as determined in other statutes like 776012, if your conduct meets the conditions of self-defense, then you can be granted immunity under the self-defense immunity statute. The definition of what qualifies as self-defense occurs elsewhere, not within the self-defense immunity statute. Unfortunately, when Florida adopted stand your ground and self-defense immunity, it did so simultaneously in different laws, but at the same time. And the phrase stand your ground has become commonly used even by legal professionals like judges who ought to know better to reference both of those doctrines. The stand your ground notion that you're relieved of a legal duty to retreat in an otherwise lawful act of self-defense, which is one thing, and self-defense immunity, which is an entirely different thing. They both have become known as stand your ground, which can only cause confusion, unfortunately. So I wish people who ought to know better would not do that, but nevertheless, they do, unfortunately. In any case, the court on the motion to dismiss, I would argue, is really based not on 776012, which is Florida self-defense statute, but on 776032, which is the self-defense immunity statute, but maybe I'm just nitpicking there. So we go on with this motion. The defendant in this case faces charges of attempted first-degree murder with a weapon and aggravated battery causing bodily harm with a weapon. To give you a sneak preview, the defendant was in a physical struggle with another man. The other man wielded a weapon. Was used as a weapon. It was a shovel, struck the defendant with the shovel. The defendant managed to seize the shovel from the other man and struck the other man with the shovel himself, causing serious bodily injury, a skull fracture, and although the man lived, and thus resulting in this charge of aggravated battery causing serious bodily injury with a weapon, to wit the shovel, and attempted first-degree murder with a weapon, again, to wit the shovel. So those are the charges. We'll step through the facts in more detail further in this motion. And there was, as I said, a first trial where the defendant was found guilty of attempted manslaughter and aggravated battery causing serious bodily harm with a deadly weapon, and judgment was entered for a 20-year sentence, followed by further probation and community control. And that judgment and sentence was overturned on collateral attack under a Florida criminal procedure rule that essentially covers ineffective assistance of counsel, as we see here. Yeah, it's not easy to highlight here. Sorry about that, folks. So that first conviction was overturned on the grounds of ineffective assistance of counsel. It's a grounds that is frequently claimed. Everyone who's convicted at criminal trial believes their lawyer was ineffective, right? That's why they think they were convicted. They had a bad lawyer. And maybe they did have a bad lawyer, but ineffective assistance is a constitutional threshold. The U.S. Constitution says you have a right to legal counsel in a criminal trial, and the courts have interpreted that to mean you have a right to effective legal counsel, which doesn't mean good legal counsel. It just means not catastrophically bad legal counsel. And apparently it was determined here that in that first trial, this defendant's legal counsel was catastrophically bad, and his conviction was overturned. Again, when your conviction's overturned on appeal, it generally does not mean that you just go free. It doesn't mean you were found not guilty. It means that first trial is essentially null and void, and the prosecution is free to try you again. Now, excuse me, most convictions that are reversed on appeal are reversed because the trial court made some kind of legal error. They're not generally reversed on factual grounds, because the appellate courts don't like to revisit factual findings of a jury. The jury saw the witnesses, saw their demeanor, assessed their credibility. The appellate court doesn't see any witnesses. The appellate court generally doesn't have witnesses appear before it. So they don't like to second guess the factual findings a jury came to. So if you think you were wrongly convicted because the jury came to the wrong factual conclusions, too bad. That's how the system works. The jury makes those findings of fact. So usually when convictions are overturned, it's because there was a legal error by the judge. He didn't allow some legal argument, or he didn't allow some particular piece of evidence. And the appellate courts determined that was reversible error. You get a new trial, and in your new trial, the new trial will have been informed that they have to allow for this legal argument that wasn't allowed the first time, or they have to admit this evidence that wasn't admitted the first time. And you go through the trial process again with that adjustment in the legal context, the correction of the legal error. Here, it's a little different. There was not a legal error by the court at trial. It was simply ineffective assistance of counsel. So on retrial, presumably the evidence and legal arguments would be largely the same. Nothing needs to be adjusted because there was no legal error by the court the first time, or at least that wasn't the grounds for reversal of the defendant's first conviction. Now, awaiting retrial a second time around, and by the way, now he has a public defender. Fortunately for this defendant, Wiley, he's got a very good public defender, as we'll see. But in preparation for his new trial, he raises the stand your ground affirmative defense, and the court held its evidentiary hearing, this mini trial of a stand your ground hearing, on January 13th, 2022. Now, I really don't like this phrase affirmative defense. There was a time many decades ago when affirmative defense had a single meaning in all 50 states. And essentially that meaning was it's a defense that both the defense has to raise. So the defendant has to say, I'm raising this defense, and the defense has to prove it, usually by a preponderance of the evidence. The burden of proof on the defense for that legal defense was on the defendant. And self-defense was a classic affirmative defense. So the defendant had to raise it, show a prima facie more than zero evidence in support of the defense, and able to be able to argue it before a jury in the first place. And the defendant had the burden of proving that legal defense to the jury in order to be acquitted on those bases. Affirmative defense has changed. The meaning of it has changed over the decades, however, and every state changed it in a slightly different way. Or states sometimes have simply decided that self-defense no longer fits the old definition of affirmative defense. Because today, in every state, all 50 of them, the burden of proof on self-defense is not on the defendant anymore. In all 50 states, the burden of proof on self-defense is on the state to disprove self-defense beyond a reasonable doubt. The defense does not have to prove self-defense by a preponderance of the evidence. That's how it used to be. And indeed, Ohio was the last state that applied that standard until just 3 or 4 years ago. But today, all 50 states say the burden of proof on self-defense is on the state to disprove self-defense beyond a reasonable doubt. So self-defense doesn't fit the traditional meaning of affirmative defense anymore. So what some states have done is they said, well, we're going to leave the definition of affirmative defense the way it was. Defendant has to raise and prove the defense, but we're going to exclude self-defense from the bucket of affirmative defenses. Other states say, no, we'll keep self-defense in that bucket, but we'll change the definition of the bucket. So for those other states, affirmative defense no longer means you have to raise it and prove it if you're the defendant. And my point here is that different states have approached this in different ways. So decades ago, when every state had the same definition of affirmative defense, you could use the phrase and everybody knew what you were talking about, regardless of what state you were in. Today, the phrase affirmative defense means different things in different states. And if you're only within one state, which is where most legal arguments happen, is within one state, one jurisdiction, then it's fine to use the phrase affirmative defense as the court is using it here, because this is a court in Florida. All the lawyers are in Florida. The argument's happening in Florida. Whatever the Florida definition of affirmative defense is, which might be different than Georgia or Alabama or any neighboring state, but whatever the definition of affirmative defense is for Florida, everyone in that courtroom is using the same definition. So there's no confusion. But the moment you start doing what I do, which is talk about these legal concepts on the internet to people in all 50 states, indeed all over the world, then if I use the phrase affirmative defense, it means different things in different places. And people can easily become confused. So I don't like to use the phrase affirmative defense. It's not harmful for the court to use it here because the court, again, is just in Florida. They're in a single jurisdiction. Everybody in that room knows what affirmative defense means in the context of that jurisdiction. But if you're speaking outside of or beyond a single jurisdiction, using the phrase affirmative defense becomes extremely hazardous. All right, so What do we know so far? The procedural posture. How did we get here? Well, this defendant was previously convicted at a first trial of attempted manslaughter and aggravated battery causing serious bodily harm. He was sentenced to 20 years in prison. His conviction was reversed on appeal on the grounds of ineffective assistance of counsel. He's coming up now on a second trial on similar charges, but now attempted murder and aggravated battery with a weapon. And before his second trial starts, he's filed a motion, which is what a motion is. A motion is a request to the court. He's filed a motion for a self-defense immunity hearing, and that's what this order is all about. So that brings us to the second major section of this order from the court. Section 2, the legal standard applicable. So this is where the court defines the algorithm, the machine. You're going to feed facts into the machine, the facts that the finder of fact believes to have been proven, into the machine, and crank the handle, and you're going to get a determination, a decision at the far end. In a trial, how this would happen is the judge, the finder of fact, would instruct the jury on the machine, would instruct the jury on the law by reading them the jury instructions. So the judge decides what laws the jury is supposed to apply to the facts. The jury doesn't pick the laws. The judge picks the laws. The judge defines the machine, the algorithm that the jury will crank the handle of to come to a ultimate verdict. The jury's role is to decide what the inputs into that algorithm are. What are the facts as the jury believes those facts to have been proven or not proven in court, watching the witnesses, hearing the arguments of the adversarial counsel. So at trial, the judge defines the algorithm and the jury defines the inputs, the facts that go into that algorithm. Then the jury in deliberations cranks the handle of the algorithm, comes out with a verdict at the other end. This is not a trial, this hearing. As I've mentioned, there is no jury. The judge plays both roles. So the judge first defines the algorithm, which is what he's going to do here. And then the judge makes findings of fact, which is what he'll do in the next major section of this order. Then he'll crank the handle, come out with a legal finding. So here this motion for immunity, self-defense immunity, invokes, meaning it's based on Florida Statute 776032, which is the state's self-defense immunity statute. Now, importantly, this statute was revised in 2017, so 5 years ago. And I'll just get to provide you with some historical context. Previously, essentially the original form, the form of Florida self-defense immunity statute prior to this change was that it was up to the defense to request the self-defense immunity hearing if they wanted to. They file a motion for a self-defense immunity hearing. And in that hearing, the burden of proof was on the defense to prove self-defense by a preponderance of the evidence, by a majority of the evidence, meaning to the satisfaction of the judge, the hearing judge in that self-defense immunity hearing. And what happened was virtually no trial judge were granting immunity. Every single time the trial judge says, no, I don't believe self-defense has been proven by a majority of the evidence. I'm denying immunity, and off the trial we go. And it got to the point where to the legislature, it appeared that the courts, which were resistant, most of the courts were not favorably disposed to this notion of self-defense immunity. And clearly the prosecutors didn't like it at all, because it had the effect of shortcutting the prosecution's ability to drag you into trial in the first place. Remember, in a lot of cases, I shouldn't say a lot of cases, but there's clearly, we cover them in detail, many cases in which prosecutors appear to be using the trial process as a punishment itself, especially in politically motivated cases where they know the trial is going to cost you hundreds of thousands of dollars, may result in your conviction, may result in you spending much or all of the rest of your life in a cage. And many prosecutors like having the power to compel you to have to go to trial and face those risks. Self-defense immunity shortcuts that. If you're granted immunity in a pre-trial self-defense immunity hearing, the prosecution's lost all power to use the process itself as a punishment. So prosecutors don't really like these self-defense immunity hearings. So the courts were largely they were unfavorably disposed. They were not granting immunity, and the legislature got to the point where they said, well, this is not working. This is not meeting our intent the intent of the legislature and passing self-defense immunity as an option. So we're going to adjust the burden of proof on self-defense immunity. Instead of the defense having to prove self-defense by a preponderance of the evidence, by a majority of the evidence, we're going to place the burden of proof at this self-defense immunity hearing on the state to disprove self-defense by clear and convincing evidence. Now, clear and convincing evidence is a legal phrase of art. It's a bit ambiguous. This motion will provide one definition of clear and convincing evidence. It's more than a preponderance. So it's more than 51% of evidence. It's less than proof beyond a reasonable doubt. Now, at trial, the state will have to disprove self-defense beyond a reasonable doubt, a very high threshold. At the self-defense immunity hearing, the state has to disprove self-defense, but to a lower threshold by clear and convincing evidence. And if he does that, if the state disproves self-defense by clear and convincing evidence, you're denied immunity and off to trial you go. But at trial, the threshold the state has to achieve in disproving self-defense is higher than it was at the hearing. Clear and convincing evidence against self-defense is not enough at trial. At trial, the state has to disprove self-defense beyond a reasonable doubt. So back in 2017, the Florida legislature had said, hey, the burden of proof on the defense, proving self-defense by a majority of the evidence in the self-defense immunity hearing, that's not working. We're not getting the desired outcome. Nobody is being granted immunity. We're going to adjust, move the goalpost, essentially. We're going to place the burden at the self-defense immunity hearing on the state to disprove self-defense by clear and convincing evidence. If the state fails to do that, the court will grant self-defense immunity. And arguably that is working better, and that is the legal standard that was applied here. So as the order notes, the statute, the self-defense immunity statute, was revised in 2017 to change the burdens on the parties. Under the current status, once a prima facie claim of self-defense immunity from criminal prosecution, also, by the way, civil suit, although for some reason the court doesn't mention that here, once a prima facie claim has been made of self-defense, at a pretrial immunity hearing, the burden of proof by clear and convincing evidence is on the party seeking to overcome the immunity. Of course, that party is always the state from criminal prosecution under the Florida self-defense immunity statute. Now, what do we mean by prima facie case? So a prima facie case is basically a more than zero evidence in support of self-defense. So if you have zero evidence in support of self-defense, well, then strictly as a technical legal matter, your conduct can't have been self-defense. Self-defense has very particular elements. By the way, if you're not familiar with those elements, you can get them here. They're not a state secret. We believe we invented this paradigm of these 5 elements of self-defense, but we share them happily with the world. You can get these for free. This is just a PDF download, an infographic of the 5 elements of self-defense. Those elements are innocence, imminence, proportionality, avoidance, and reasonableness. The infographic lists them and provides a brief description, a few sentences of each one. These are the building blocks of a claim of self-defense, folks, and these are cumulative and required, meaning if any one of the required elements is missing, meaning there's zero evidence in support of it, or the finder of fact doesn't believe the evidence in support of it, if any required element is missing, your privilege of self-defense isn't just reduced or mitigated, it's eliminated. Self-defense as a legal defense is like a light switch, folks. Either you 100% qualify and you have zero legal liability for that use of force, or you 0% qualify. You have 100% legal liability for that use of force. And the building blocks of whether or not you do qualify, the check boxes, are these 5 elements of self-defense. So if you're not familiar with these 5 elements of self-defense, folks, I urge you at the very least, get this free infographic. Does not cost a penny. And you can get that at lawofselfdefense.com/elements. Lawofselfdefense.com/elements. By the way, if you're an instructor, have a classroom, you'd like a poster size of this infographic, we also have those available. Those are not free. Obviously, we need to print those and ship them. But if you're interested in a poster size of this, you can also get that at lawofselfdefense.com/elements. But if all you want is a PDF download, totally free. And if you don't understand these 5 elements, you can't possibly understand how use of force law works. So I would urge you to get that at lawselfdefense.com/elements. So the prima facie case is you have to first show up in court with more than zero evidence on each of the required elements of self-defense. Now, I mentioned the 5 elements. There's up to 5 elements. That's the maximum number. That's good news. There's not 500 check boxes for self-defense. There's not 50 check boxes for self-defense. There's only 5, up to 5. There are circumstances in which not all 5 elements are required. So, for example, in a stand your ground state, normally the element of avoidance deals with whether or not you had a legal duty to retreat before you acted in self-defense. Normally, in a stand your ground state, in an otherwise lawful act of self-defense, avoidance is not required. If avoidance is not required, you only have 4 elements you have to worry about in your claim of self-defense: innocence, imminence, proportionality, and reasonableness. So it's not always the case that all 5 elements are required, but the good news is there's only up to 5 elements required, and those are in that infographic. So for this prima facie case in Florida, let's assume avoidance is relieved here because of Florida stand your ground status. You have to come up with more than zero evidence in support of each of the 4 remaining elements of self-defense: innocence, imminence, proportionality, and reasonableness. Once you have more than zero evidence, you've met your prima facie burden. If there's zero evidence on any of the required elements, then strictly as a technical matter, your conduct cannot have been lawful self-defense because you didn't check one of the boxes. The moment there's more than zero evidence, however, there's something for the finder of fact to consider in determining whether or not that required element has been checked. So that's the test here, meeting the initial test. Before you can argue self-defense in court at all, you have to be able to show there's more than zero evidence in support of each of the required elements. That's what this prima facie claim is. And what the order is pointing out here is that once the defendant has done that, shown more than zero evidence, maybe not a lot, but more than zero evidence for each of the required elements of a claim of self-defense, in this pretrial hearing, once the defendant has met that burden, then the burden of proof on self-defense shifts to the state to have to disprove self-defense by clear and convincing evidence. If the state can do that, your request for self-defense immunity is denied. If the state fails to meet that burden of disproving self-defense by clear and convincing evidence, then the hearing judge is supposed to grant your request for immunity. You're no longer subject to prosecution. You're no longer subject to civil suit for that use of force. Now, the judge here references immunity from criminal prosecution provided under Florida statute 776032, and then he reads a relevant portion of the statute. So the relevant portion is: a person is justified in using or threatening to use deadly force. See if I can get this to bold. If he reasonably believes that using or threatening to use such force is necessary to prevent imminent or great bodily harm, imminent death or great bodily harm to himself or another, or to prevent the imminent commission of a forcible felony. A person who uses or threatens to use deadly force in accordance with the subsection does not have a duty to retreat, has the right to stand his or her ground. That's the stand your ground language there. It's not a separate statute. It's just embedded in existing Florida self-defense statutes. And it did not used to exist. So this was the language that was added when Florida became a stand your ground state. Has the right to stand his or her ground if the person using or threatening to use a deadly force is not engaged in criminal activity, and is in a place where she or he has a right to be. So this is basically setting out the elements of self-defense and noting that avoidance is not required in an otherwise lawful case of self-defense. So you have to be facing an imminent threat, right? That's the element of imminence, against some unlawful use of force against you. The force needs to be, if you're going to use deadly defensive force, the force you're threatened with has to be death or great bodily harm. That's proportionality. You have to reasonably believe. That's the element of reasonableness. Forcible felony, again, that means the other party's the aggressor. You're the innocent victim of their forcible felony. That's the element of innocence, once more. And if you meet these elements of self-defense under Florida law, you do not have a duty to retreat. So they're saying the element of avoidance is off the table if you meet the conditions for having avoidance taken off the table. So it's very common for statutory stand your ground. Not all stand your ground in every state is statute-based. California is a very strong stand your ground state. You might be surprised to hear that, but they are. They have one of the most robust stand your ground provisions in all the 50 states. California does. But you won't find a California stand your ground statute because California stand your ground law is not in statute. It's in case law. It's in court decisions. And case law is just as viable law as is statutory law. And in states that are stand your ground by case law, typically it's just a blanket relief of a legal duty to retreat. In states that are stand your ground by statute, normally when a statute is created, there's debate and compromise and conditions are added. That's the nature of the sausage making of the legislative process. That happened here in Florida. So you don't automatically qualify for stand your ground in Florida. You have to meet certain conditions. Those conditions include not being engaged in criminal activity and being in a place where you have a right to be. If you meet those conditions, you qualify for quote unquote stand your ground. You're relieved of that element of avoidance. So these are essentially the elements of self-defense that have to be met under Florida law. The statute, the order continues, and case law, meaning court decisions, appellate court decisions, reveal a multi-step analysis of self-defense immunity. The defendant must, and again, here it's really just stepping through the elements of self-defense, must reasonably believe using such force was necessary to prevent imminent death or great bodily harm, or to prevent the imminent commission of a forcible felony. Now, here's one interesting thing here. I mentioned that stand your ground in Florida has conditions. You have to qualify for stand your ground. You have to qualify for being relieved of a legal duty to retreat, being relieved of that element of avoidance. And it's right there in the statute. We just looked at it. You don't have a duty to retreat. You can stand your ground if you meet these conditions, not be engaged in criminal activity, being in a place you have a right to be. The Florida courts have decided that those same conditions apply to a different legal doctrine, self-defense immunity. Remember, I talked earlier, stand your ground is one legal doctrine. Self-defense immunity is a completely different legal doctrine. In fact, self-defense immunity has its own statute, 776032. And that statute says nothing. The self-defense immunity statute says nothing about not being engaged in criminal activity and being in a place you have a right to be. So my reading of the law would be that, yes, those conditions have to be met to qualify for stand your ground, for being relieved of that legal duty, that legal element of avoidance. But self-defense immunity does not have those conditions. Of course, I'm not in charge of things, and certainly the Florida legislature did not put those conditions into the self-defense immunity statute. But this is one of the reasons that just relying on the plain English reading of a statute, the apparent plain English meaning of a statute, can be so dangerous, because the Florida appellate courts have decided to read into the self-defense immunity statute conditions that are not in the statute. And those conditions are the same conditions that apply to stand your ground, that are in the stand your ground statute, but are not in the self-defense immunity statute. But the Florida courts say, no, we're going to pretend that self-defense immunity has those same conditions. Why? I don't know. I think that's bad law. I think the courts are wrong. This is a faulty interpretation of self-defense immunity law, but it is the interpretation that the courts will apply, because the trial courts and these hearing courts apply the law as the appellate courts tell them to. And the appellate courts have told them, as far as we're concerned, not being engaged in criminal activity and being in a place you have a right to be are conditions of self-defense immunity, even though they don't exist in the self-defense immunity statute. So, again, it's a pet peeve to me. I think that's bad law, but it is the law as it exists in Florida. So my point really here is, if you go read the self-defense immunity statute, you would not know this, because these conditions are not in the self-defense immunity statute. So if you take a CCW course, a self-defense course, a concealed carry permit course, and they get to the legal part, and all they do in the legal part is read you some statutes, you would not know from the reading of the self-defense immunity statute that these are conditions of self-defense immunity, because they're not in the self-defense immunity statute. The only way to know would be to also know the case law. And folks, if you've read your state self-defense statutes and you have not read the case law that interpret and apply those statutes, you don't really know what the statute means, because just like here, the statute does not necessarily mean what it appears to mean. It does not necessarily mean what the legislature intended it to mean. It means what the courts that interpret and apply those statutes to real people in real cases say it means. And what they say it means can be quite different than the apparent plain English reading of the statute. So be cautious about relying simply on statutory language. So we continue. A defendant is not entitled, let's see, To assert the reasonable use of force if he was involved in criminal activity just prior to the shooting. I'll skip over that. It's not really important for the purposes here. Well, it does reference a case. It references something here called the Shavers element. I'm not sure it matters really. This paragraph here looks just like they're stepping through, again, just the elements of self-defense, mostly focusing here on reasonableness. So does the situation objectively qualify for the use of deadly force? Objectively qualify. So the element of reasonableness, one of the 5 elements of self-defense, has 2 subcomponents. Subjective belief, what you thought in your head, your genuine good faith belief in the need to use force in self-defense. But subjective belief, no matter how genuine and in good faith, is not enough to satisfy the requirements of the element of reasonableness. That subjective belief also has to be objectively reasonable. A hypothetical, reasonable, and prudent person in your circumstances would have shared that subjective belief. So another way to say that is an irrational, even of genuine good faith, an irrational subjective belief is not enough to meet the conditions of the element of reasonableness. That subjective belief also has to be objectively reasonable. Does the situation involve the use of deadly force, threat of deadly force, forcible felony? That gets us into the deadly force bucket under the element of proportionality. Would a reasonably prudent person in the same circumstances as the defendants conclude that the use of deadly force was necessary? And this involves looking at both objective and subjective analysis. Did the defendant believe, that's the subjective, that a particular level of force was necessary? And was that force such that the hypothetical, reasonable, and prudent person would reach the same conclusions? Then they define forcible felony. This won't surprise anybody. Forcible felony is another circumstance in which Florida allows for the use of deadly defensive force. So the traditional circumstance is that you're facing an unlawful threat of death or serious bodily harm, or you're resisting a forcible felony, which means treason, murder, manslaughter, sexual battery, carjacking, home invasion, robbery, burglary, arson, kidnapping, aggravated assault, aggravated battery, aggravated stalking, aircraft piracy, meaning hijacking, unlawful throwing, placing, or discharging of a bomb, or any other felony. So this is a catch-all now. Any other felony which involves the use or threat of physical force or violence against any individual. Basically, all of these have death or serious bodily injury kind of baked into the cake. So the order continues, the approved jury instruction for self-defense notes that the finder of fact, again, at trial, that would normally be a jury. At this self-defense immunity hearing, that's the judge. The judge is the finder of fact at this hearing. There is no jury. But the finder of fact must also find that all the elements of the underlying forcible felony have been met. So each of those enumerated list of forcible felonies, each of those are independent crimes. They each have their own legal elements. So if you're defending yourself and you're justifying your use of deadly defensive force as defending yourself against a forcible felony, you have to convince the jury that the forcible felony actually existed. So that's what the court is looking at here. Here, remember, there was a fight between the defendant and the other man, and initially the other man was attacking the defendant with a shovel, and then the defendant got the shovel and fought back. The defendant's going to be arguing that I was defending myself against that other guy's aggravated assault, aggravated battery. So he'd have to be able to convince the finder of fact in this hearing, the judge, that the elements of those crimes were met as having been committed by the other fellow first, and that the defendant was therefore defending himself against that. Once the defendant raises the defense, the burden is on the state by clear and convincing evidence. We already talked about this. The shifting of burdens postdates the offense in this case. So what the court is saying here is, remember I talked about how the legislature changed the burden of proof for self-defense immunity. It used to be the defendant had to prove it by preponderance of the evidence. Now the state has to disprove self-defense by clear and convincing evidence at this hearing. That change happened after this fight occurred, but nevertheless, the courts have held that because of the procedural nature of the change, the defendant is entitled to the current version of the burden of proof, not the version that existed at the time. So the shifting of the burden is effectively retroactive. So what do we mean by this burden of proof? So now the court's going to share with us a different court's explanation of the difference between preponderance of the evidence and clear and convincing evidence. So they're quoting here. While the preponderance of the evidence is simply the greater weight of the evidence, or evidence that is more likely than not tending to prove a certain proposition, clear and convincing evidence is evidence making the truth of the facts asserted highly probable. Now, they're not proven beyond a reasonable doubt. That would be a still higher threshold of evidence, standard of evidence. But it is higher than a mere majority. It's higher than 51%. It makes the facts asserted highly probable. It continues, clear and convincing evidence requires that the evidence must be found to be credible. Of course, all evidence has to be credible to count at all. The facts to which the witnesses testify must be distinctly remembered. The testimony must be precise and explicit, and the witnesses must be lacking in confusion as to the facts in issue. The evidence must be of such weight that it produces in the mind of the trier of fact a firm belief or conviction without hesitancy as to the truth of the allegations sought to be established. So that's the burden here for the state. The state has to disprove self-defense by this standard of evidence, clear and convincing evidence, at the self-defense immunity hearing, or the defendant is supposed to be granted immunity. So that's the legal algorithm. That's the legal threshold and where the burden is placed. That's the machine on which the candle will be cranked once we put the facts into the machine. And you crank the handle and you get a decision out the other end. So now we have the machine defined. We have to look at what the facts actually are. And this is, as I mentioned, an adversarial process. So there's two versions of the facts. The state has a version of the facts, a narrative, a view of the evidence that is inconsistent with self-defense. And the defense, of course, has its own version of the facts, its own narrative, its own view of the evidence that is consistent with self-defense. And both of these arguments, these competing narratives, these adversarial views of the evidence, will be presented to the finder of fact, which in this hearing is the judge, the hearing judge. And the judge will decide which version of the facts he believes to have been proven and which he believes have been proven or disproven to the required legal standard, here by clear and convincing evidence. So we're going to hear the defendant's version of the facts first, and then we'll hear the state's version. For the state to win, in other words, for the defendant to be denied immunity here, the state has to convince the judge that its narrative of the evidence has been proven by that clear and convincing evidence, that the judge would have no hesitancy in believing the state's version of events. If the state fails to meet that threshold, the judge is obliged to grant the defendant immunity. So as a preface, the court mentions they heard testimony from several law enforcement officers, from the defendant, from members of the defendant's family, who presumably were witnesses. The court also considered trial testimony from one of the medical providers regarding the injury suffered by the victim, which was grievous, again, a fractured skull. The court also received several photographs into evidence of both the scene of the incident and the injuries to the defendant and to the victim. So both men suffered injuries in the course of their fight. So that's the body of evidence that the court was presented. Now the court addresses the defendant's version of these events. The defendant and the victim, Herbert Thorne, knew each other. There was no history of animosity. The defendant had done some work on the victim's land for an agreed upon fee. He had only been paid about half. While traveling with a family member, this would be one of the witnesses the court heard from here, James Campbell is a family member, to a family home near the victim, the defendant decided to stop at the victim's home and inquire about the payment. So the defendant and his family member are traveling to that family member's home. That family member happens to live near the victim. The victim owes the defendant money, according to the defendant. The defendant said, hey, as long as we're going by this guy's house, let's stop and I'll see if he'll pay me the rest of the money. So upon arriving, the defendant and victim engaged in what all agree was lighthearted banter. Are you working hard or hardly working? He then made a reference, the defendant, to having permission from code enforcement for all the work being done. So this was probably a joke. Again, lighthearted banter. Hey, did you get a permit to do all this? And we all know many landowners, technically probably were supposed to get a permit to do something like put up a fence or whatever, and they don't bother, and nobody bothers them about it. So it's just nobody really cares. It's just a kind of joke that two guys might make with each other. Unfortunately, and the defendant says, hey, we used to joke about this all the time, about getting permits, not having permits. This was just a common joke that we made. Unfortunately, it turns out that code enforcement had recently visited the defendant. The defendant had just had his own issues with code enforcement. So code enforcement had come to the defendant's home and I guess found some marijuana there. Wow, marijuana growing in Florida. Who would have known? But anyway, that might have prompted the defendant to make that joke in the first place, his own recent interaction with code enforcement. The conversation then turned to payment. The defendant was standing either on the public right-of-way or perhaps just on the victim's property. The evidence was ambiguous on this point, so it wasn't clear where the defendant was standing. The defendant, which is certainly not evidence that's clear and convincing, right? The very definition we read earlier said to be clear and convincing, it has to be unambiguous. The defendant asserts the victim made the first aggressive moves by threatening him with a long-handled shovel he was holding. He flipped out. The defendant claims the victim first swung the shovel towards him, and the defendant tried to step out of the way. The victim tried to poke him in the leg with the shovel, held down at an angle, pointed to the defendant's lower legs. And the defendant explained that a tear on his jeans was caused by the shovel striking him. So here the defendant's describing this shovel attack by the victim, which he says was the initial aggression here, which he would need to say, right? So that's the element of innocence, that it was not you who was the initial aggressor. It was the other party who was the initial aggressor. And you're defending yourself against their unlawful initial aggression. The order continues in this narrative of the defense version of the facts. The defendant fell, and as he stood up, the victim, it says him, it means presumably hit him on the head with the shovel. The victim also attempted to poke at him in the face with the handle of the shovel. The defendant deflected that attempt with his hand and suffered a puncture-type wound to his hand, which was also visible on the photograph. So evidence of actual injury. You're not required to suffer injury before you can defend yourself from an attack. But if you have suffered injury and it's documented, well, that is evidence consistent with your claim that you were the victim of a forcible attack. The wound is on the palm of the hand and the fleshy part of the palm near the wrist, so it looks like a defensive wound. The defendant grabbed the handle of the shovel with both hands. The two men wrestled over the shovel. The defendant was able to wrestle the shovel away. At this point, the victim grabbed the defendant by the shirt. The defendant tried to hit the victim with the shovel to get away from him. He believes this is when the victim was hit in the leg. So presumably the victim has a leg injury as well. Then the defendant claims the victim lunged, which ripped the defendant's shirt and stepped away. The victim then came back in towards him. The defendant then swung the shovel with all I had, as hard as I could swing. The victim took several steps away and then fell towards his property and started rolling. The defendant claims the fence line shown on the photographs is the property line. He claims the area in which the altercation occurred was the right-of-way. So here the defendant's trying to argue, Your Honor, I know if this occurred on the victim's property, that would raise additional legal issues. The victim could claim defense of property or that I was a trespasser. Here the defendant's arguing, hey, look, there's evidence here that I was in a right-of-way. I was not on the victim's property. The defendant continues. The defendant saw the other person there, quote unquote, Mr. Randy, start to approach him. He was outside himself. I guess that's a referral to his own subjective state of mind, the stress of being in really a life or death fight, and heard his brother-in-law, that would be James Campbell, tell him to come with him. The defendant then called to the other person to call 911. He then got in his car and left the victim's home. The defendant then traveled with his family member to the family member's home, waited there while law enforcement was called from that house. So the defendant called the police. The police didn't have to go find the defendant. That's good. The defendant waited, met with law enforcement, spoke to officers, and was photographed. Now we get to the victim's injuries. The victim was treated by EMS, taken to a local hospital. Emergency surgery was performed. The court says it should be noted the defendant objected. objected to evidence here, objected to the introduction of the wound photographs. The court never ruled formally on the record. The court does not find that for the purpose of the stand your ground hearing, meaning the self-defense immunity hearing, the court considered the evidence of damages relevant to corroborate or refute either version of the events. As noted in the hearing, evidence admitted for this hearing is not necessarily admissible at trial. So that's another interesting point. The evidence, remember we talked earlier about how these preliminary hearings define the legal battlefield for the trial. They define the legal arguments and evidence that will be presented to the jury. But in the self-defense immunity hearing, the evidentiary boundaries, the playing field is broader than it is at trial. There's evidence that's not admissible at trial, not admissible by a jury, that is admissible by the hearing judge in the self-defense immunity hearing. The judge is saying here they introduced the presumably the rather graphic photos of the victim's head wound, but the court's saying, listen, I didn't actually make a ruling on whether that's admissible or not. It didn't play a big role in my decision either way. The court continues, the laceration went not only through the skin, but also sliced open cranial bones, thus demonstrating the force with which the defendant struck the victim. The victim suffered a depressed skull fracture, requiring extensive reconstruction and rehabilitation. The victim also suffered a puncture wound to the leg, which has a V shape. Okay, so obviously that wound is serious bodily injury, right? Force likely to cause death or serious bodily injury. The defendant here used deadly force as legally defined upon the victim. So he has to meet the elements required for the use of deadly defensive force in this scenario. So that was the defense version of the facts. Then the victim's version was next. The victim testified by Zoom over the objection of the defendant. I guess the objection here would have been at trial. A defendant has the right to face his accusers. You generally want that to happen in person. The accuser, any party testifying against your interest ought to be in court. So psychologically, the theory is it's harder to lie about people if you have to look them in the eyes. It also gives the jury the most comprehensive means of evaluating the witness's testimony and credibility. So the objection here would not have been to the victim testifying at all. It would have been to the victim testifying on a TV screen. But in any case, the court allowed it. Of course, this is the COVID era, so testifying by TV has become more common. And again, this is a hearing, a pretrial hearing. So this might not have been permissible. I mean, the privilege to face your accuser is a constitutional privilege, U.S. Constitution. So this probably would not be permitted at trial. But again, the playing field for purposes of this hearing, this pretrial self-defense immunity hearing, are broader than what would be permissible at trial. So here at the hearing, the victim was allowed to testify over Zoom. The jury could see the victim's face and upper body throughout the testimony. The camera was focused on his face the entire time. So this goes to that point of the finder of fact. Here, the judge, of course, being able to see the witness testify in order to view their demeanor, determine their credibility. The courtroom Zoom projection was placed just next to the defendant's table where he could observe the victim testify directly. The court was aided in its viewing by a projection onto a monitor on the bench right in front of the judge's seat. The view of the victim's face and upper body was better than in a live hearing. All right. Well, that only answers part of the issue here, right? The reason you're allowed to face your accuser, you have the constitutional right to face your accuser in court, is supposed to be, as I mentioned, because psychologically it's harder for someone to lie about you if they have to look in your face while they're doing it. This Zoom doesn't appear to satisfy that component of the right to face your accuser. Sure, the defendant could see the witness and the court could see the witness, but the witness couldn't see the defendant, and that's part of the point. You're supposed to have to lie while looking the defendant in the face. But in any case, again, this is a hearing, not the trial itself. It continues the victim's version of the facts. The victim agreed that he knew the defendant and that when the defendant arrived, he felt no specific threat. He was doing cleanup work at his yard, was using the shovel partially to assist him in walking. He'd suffered a traumatic injury in a motorcycle accident in his past and had trouble walking. The victim claims the defendant approached him and demanded his money. He asserts the defendant was aggressive the whole time and began the conversation by asking, who was working with him that day and whether he was paying them. He then began cursing at the victim and threatening him. He then claims the defendant approached him and struck him on the head with his hand. He claims the defendant must have been holding something in his hand because of the shock he felt when struck on the head. The victim asserted that he held up the blade of the shovel to shield his face from further blows. The victim claims the defendant then hit him again, and he fell to the ground and passed out. When he woke up on the ground, the defendant hit him again with the shovel, causing him to pass out again. He denies ever making any aggressive moves toward the defendant. He claims that he was struck in the leg while he was on the ground. He was not sure whether that injury was suffered while he was on the ground or not. He asserted he was hit repeatedly while on the ground. The victim denies ever hitting the defendant with the shovel. Of course, the defendant has that wound that was photographed on his hand. He reiterated that the defendant hit him multiple times and asserted that the defendant must have had something in his hand. Upon further examination, he admitted that at the original trial, he claimed it was only the defendant's hand. So this claim of an object in the defendant's hand is something new since the first trial, where the victim had also testified. He claimed that there was a woman sitting in the passenger seat of the car the defendant drove. He admitted that he knew James Campbell and Lisa Campbell, the family members of the defendant who lived nearby. He denied there was a man in the car. He knows that Mr. Campbell has a beard. He specifically denied there was a male with a beard sitting in the front seat of the car. So that was the defense version. So we've heard from, the victim's version. Now we've heard the defense narrative. We've heard the victim narrative, which would be the state's narrative, inconsistent with self-defense. The court also heard from other witnesses. The court heard testimony from Lisa Campbell, the sister of the defendant. She denied she was in the car during the incident. She observed the defendant when he arrived at the family home and described him as all tore up. She observed he was upset and wanted help for the victim. The court also heard testimony from James Campbell, the defendant's brother-in-law, who the defense says was in the car during this incident. Campbell testified he heard the conversation between the defendant and the victim and corroborated that it had a friendly tone at first. He heard the conversation turn aggressive, saw the victim try to poke the defendant in the leg with the shovel tip and in the face with the shovel handle. He saw them wrestling over the shovel. He saw the defendant take the shovel. The victim backed off, then came rushing back towards the defendant. He saw the defendant swing the shovel and the victim fell to the ground. The defendant dropped the shovel at the spot where the fight took place. Mr. Campbell then went in and gave a bear hug to the defendant. So that's the brother-in-law, grabbed the defendant. The victim rolled away from them back onto his property. The defendant was crying and upset. They left the scene and went to their nearby family home. So we've heard this rolling thing a couple times now, that after the victim fell to the ground, he rolled. Presumably, this is part of the defense argument that, hey, you might have found the victim's, body, or he may have, there's evidence that at some point he was laying on the ground on his own property, but that's not where the fight took place. The fight took place where I used my defensive force was off the property. Again, this would be to argue against any state claim that the fight took place on the property, which would raise additional legal issues, make things more difficult for the defense because it would raise legal issues of the victim acting in defense of property, that the defendant might have been a trespasser, therefore not in a place he had a right to be. And remember, being in a place you have a right to be is something that the Florida courts, not the self-defense immunity statute itself, but the Florida courts have said is a condition of self-defense immunity. So if the defendant here were believed to be a trespasser on the victim's property, he doesn't qualify for self-defense immunity on that basis alone, regardless of the other merits of his claim of self-defense. So several law enforcement officers also testified. One who responded first to the defendant's home specifically recalled that he did not observe an injury to the defendant's knuckles. Injuries to the knuckles are normally aggressor type injuries. So not seeing them would be consistent with self-defense. I mean, of course, you can punch somebody in self-defense, but that's typically how it would be viewed here. Another deputy who responded first to the scene of the alleged crime presented the photographs taken of the scene. He was unable to affirmatively display the boundary of the property. Again, this property issue here again. So it's ambiguous, and ambiguity is in favor of the defense because the state has to disprove self-defense by clear and convincing evidence, which means evidence that is not ambiguous. It's evidence that is unambiguous. This second officer did identify the victim's location when they arrived on scene. So they found the victim on his property. The counterclaim is maybe, but that's not where the fight occurred. We fought here off the property, and then the victim rolled back onto his property. So those are the facts. That's the evidence that was presented to the court. The court has to make determinations of what evidence they believe is credible and not credible. Take the evidence they believe is credible and feed it into that algorithm, into that machine that we discussed earlier, crank the handle of the legal standards machine, and come to have a decision come out the other side of the handle. So here in this section 4, the court describes its conclusions of facts and law. First, the defendant has to meet that prima facie burden, right? More than zero evidence in support of each of the elements of self-defense. The court here says the defendant established this prima facie case with his assertion of the facts as presented in the motion for this hearing and in the court hearing itself. The burden, therefore, shifts to the state to prove by clear and convincing evidence that the defendant is not entitled to defend himself by use of deadly force. If the state fails to meet this burden of clear and convincing evidence against self-defense, then self-defense has been established for purposes of self-defense immunity, and the defendant is granted immunity. The court continues. The court has carefully considered the testimonial evidence, the limited physical evidence, that would be the photographs, for example, considered the demeanor of the witnesses and weighed their potential for bias, and particularly by the family members, right, of the defendant. Clear and convincing evidence is a high burden. The conclusion must be highly probable. The testimony must be precise and explicit, and the witnesses must be lacking in confusion as to the facts in issue. We saw, for example, that the victim was uncertain about some facts in his narrative and inconsistent. Some of his testimony in the hearing was inconsistent, contrary to his testimony in the first trial. The court continues, the evidence must be of such weight that it produces in the mind of the trier of fact a firm belief or conviction without hesitancy as to the truth of the allegations sought to be established. So that was just a court repeating what the legal threshold here is. Applying that standard to the state's evidence, the court finds that the state's evidence fails to meet the mark, fails to disprove self-defense by clear and convincing evidence. Indeed, the court finds the sequence of events described by the defendant to be far more credible. The defendant gave a detailed description of the events. His brother-in-law came in and gave an equally detailed description without having heard the defendant's testimony. So just like in a trial, normally people who are prospective witnesses in a trial are not allowed to sit in the courtroom and hear the testimony of previous witnesses. The idea being that the later witness might tailor their testimony to be consistent with what they heard the previous witness say. So to avoid that, witnesses are normally not allowed to be in the courtroom, at least until they've testified themselves and their testimony is over. But if they're still subject to recall as witnesses, they still wouldn't be allowed to sit in the courtroom. In this case, the brother-in-law was not sitting in the courtroom when the defendant testified, so the brother-in-law could not, in theory, tailor his testimony to that of the defendant. Of course, I guess they could have done that before they ever walked into the courtroom, but in any case, this was a factor considered by this court. Their version of the events, the defendant and brother-in-law, were remarkably similar, yet bear no indicia of being rote recitation of an agreed-upon narrative. So this is what I just said. I guess they could have agreed to a story before they ever walked into the courtroom, but the judge is saying, it didn't sound like that to me. The court continues. Notwithstanding the testimony of the victim, the court finds that the victim himself used deadly force to threaten the defendant when he began to approach him and jabbed at him with the blade of the shovel. Those actions constituted an assault and then a battery with a deadly weapon. So remember, the defendant here is saying, hey, I was defending myself against a forcible felony. The forcible felony would be assault and battery with a deadly weapon committed by the victim. The court here is saying, yes, I find the elements of assault and battery with a deadly weapon to have been proven to my satisfaction. That means a forcible felony against the defendant was proven to my satisfaction, the court's satisfaction. And of course, forcible felony is one of the circumstances in which deadly defensive force can be used. The court continues. While a shovel is not per se a deadly weapon, it is certainly capable of being misused in such a way as to produce death or great bodily harm. Using the pointed blade of the shovel and jabbing it towards the legs of another qualifies as such force. So this is worth commenting on. Some things are inherently deadly weapons. A gun is inherently a deadly weapon. A knife, at least a knife used in the way it would be used in a fight, a physical confrontation, is a deadly weapon. They are tools intended and designed to inflict death or serious bodily injury. Most objects are not inherently deadly weapons. They're not designed and intended to be used to inflict death or serious bodily injury. They have some other innocuous use, like a shovel is used for digging holes, not for inflicting death or serious bodily injury. But the truth is that virtually any object can be used to inflict death or serious bodily injury. It depends on the manner of its use. A shovel being used to dig a hole is not being used as a deadly weapon. A shovel being used to strike someone in the head arguably is being used as a deadly weapon, being used in a manner likely to cause death or serious bodily injury. A plastic shopping bag from the grocery store, not normally thought of as a deadly weapon, not per se, not inherently a deadly weapon. But if you duct tape it over someone's head so they can't breathe, is it inflicting death or serious bodily injury? Sure. In that manner of use, it's being used as a deadly weapon. A pillow, embroidered pillow with a kitten on it, embroidered kitten, not something you would think of as a deadly weapon. But if it's being used to smother someone, its manner of use is to inflict death or serious bodily injury. So there are many, many objects. I would argue most objects that exist in the world have the potential to be used to inflict death or serious bodily injury. Whether they are a deadly weapon depends not just on their inherent nature, but on the particular manner of use. Here the court's saying, look, a shovel's not inherently a dangerous weapon. It's not a gun, but it can be used as a deadly weapon. And when it is used to inflict death or serious bodily injury, it is being used as a deadly weapon, sufficient to meet the conditions for the crime of assault and battery with a deadly weapon. Using the pointed blade of a shovel qualifies as such force, meaning deadly force. It would produce more than mere bruises, which would be not serious bodily injury if contact were made, and could produce deep tearing of the skin and potential damage to the bone. Indeed, when used in this case, in defense, that very same shovel had that grievous effect. Continues the court's conclusions. While the state never directly argues it, they seem to assert that the victim was entitled to use deadly force in response to the defendant's asserted verbal and perhaps physical threats. So if the victim here was privileged to strike at the defendant with the shovel, if that use of force by the victim was legally justified, well, then the defendant wouldn't have a privilege to defend himself. Well, let me retract that. The state seems to be implying here that the victim had a legal privilege to use the shovel as a deadly weapon against the defendant. That wouldn't necessarily mean the defendant wouldn't have a privilege of self-defense, but what it would do is undercut the forcible felony justification for the defendant's act of self-defense, because if the victim were legally justified in striking at the defendant with the shovel, then he was not committing the crime of aggravated assault and battery with a deadly weapon. He was not committing that underlying forcible felony, and there would be no forcible felony justification for the defendant to then use deadly force against the victim. But the state never directly argues this, but seems to assert that argument. The court does not find that the defendant made any threat, certainly not by clear and convincing evidence. The weight of the evidence strongly points to the victim as the primary person who turned an uncomfortable conversation at its worst, "Where's my money?" Into a violent encounter. It doesn't matter if the defendant's demand for money was aggressive in nature, as we use the word aggressive in a colloquial sense. It matters who was the initial physical aggressor, who is the first person to threaten or use physical force. The court says it's determined that was the victim, not the defendant. The state asserted through various arguments that since this encounter occurred on the victim's property, that's, again, ambiguous, but a claim by the state, that the victim was entitled to the provisions of Florida's Defense of Property statute regarding defense of home. This could arguably raise a legal presumption that the victim was in reasonable fear of death or serious bodily injury. This statute somewhat lessens the burden to justify the use of threat of force, of deadly force. Again, it creates a legal presumption that the defender had a reasonable perception of a deadly force threat. However, the court continues, the state most definitely did not prove that this incident took place on the victim's property. Indeed, the testimonial and physical evidence strongly suggests the events took place in the right-of-way, adjacent to the property. Even if the events took place on the victim's property, the state has not proven the victim had the right to initiate his own defense of property in a manner sufficient to negate the defendant's later use of force. So the court's saying that, listen, the issue of whether or not this happened on the property is not only ambiguous, but the weight of the evidence is against it. Certainly, it's not proven by clear and convincing evidence, which is the legal threshold the state has to meet. The court continues, finding that the victim was indeed the aggressor. So this is a finding of fact by the court. The court must then determine whether the response by the defendant with deadly force was justified. So, of course, the court's determined the defendant was the victim. We use the victim for the other person's name, but the defendant was defending against unlawful force against him. That's not enough by itself to justify the use of deadly defensive force by the defendant. The defendant must have been facing not just an unlawful attack, but an unlawful attack that was deadly in nature, likely to cause death or serious bodily injury, or that it was a forcible felony. Either would be sufficient, really. So the court's essentially already concluded that the forcible felony condition has been met. I'm not sure why they need to also do this rationale for justifying the defendant's use of deadly defensive force, but the court's doing it anyway. The court must then determine whether the response by the defendant with deadly force was justified. The court finds that the defendant was entitled to defend himself up to and including the mortal blow with which he struck the victim. I don't think the blow was clearly not actually mortal, because the victim testified in the hearing by Zoom, but I think the court means it had the potential to be mortal. After the initial approach by the victim with the shovel, the two men began to wrestle over the shovel. The defendant was entitled to attempt to disarm his attacker. It appears he succeeded. Then, for reasons unknown and unexplained, the attacker-victim charged towards the defendant. So the court's kind of taking a generous view here. Arguably, one could argue that once the defendant had seized the shovel from the victim was no longer an imminent deadly force threat. He might have been an imminent deadly force threat while he was wielding the shovel against the defendant. But once the defendant had seized the shovel, he'd stripped the victim of that ability. And again, remember, this was a victim who apparently could hardly walk because unassisted because of a previous motorcycle injury. Now, the counter argument to that would be that, sure, I've got the shovel now, but I managed to take it from him. Maybe he'll manage to take it from me. He is continuing his assault on me. And I believe it's because he's trying to rearm himself with the shovel that I have. I guess that's the argument that the court found compelling. I just want you to be aware that the counter argument also exists. That might be found compelling by a different court. That, sure, up until the point you had the shovel, in other words, if the victim had continued to attack with the shovel and the defendant had pulled the gun and shot the victim, well, then he was still facing an imminent deadly force threat. But perhaps once the defendant had seized the shovel, the window of eminence had closed. The court continues. It's crucial to note here that the description of events is highly consistent between both the defendant and his brother-in-law. The court already mentioned this. Moreover, the brother-in-law's description came even closer to that of the defendant during cross-examination. As the state sought to pick apart the witness's testimony, the witness provided even more detailed and closely matched descriptions to those of the defendant. So, just as an aside, that's not what you want on cross-examination. On cross-examination of the other party's witness, you want to impeach their testimony, weaken their testimony. Here, the court's noting that contrary to what the state would want, in fact, the brother-in-law's testimony actually got stronger for the defense on cross-examination. The court notes, again, this is without the benefit of having heard the defendant's testimony and without the opportunity to consult with the defendant. The court cannot overstate here that the overall effect of the brother-in-law during his testimony further enhanced his credibility. While he had elements of a narrative he wished to convey, both counsel did an admirable job in limiting him to the facts truly at issue. It was in their control of his excursions that both elicited the most significant corroborating evidence. So one of the struggles you often have with witnesses is they want to talk about things that aren't relevant to the actual legal questions in the case. So one party or the other party will object when these irrelevancies are brought up because they could influence the jury and they're not supposed to. Apparently, the brother-in-law brought up these irrelevancies, these excursions in his testimony, both on direct and on cross-examination. And ultimately that led to evidence the court found even more compelling. In contrast, the victim's description seems wholly disengaged from the other two. He claims the defendant first struck him with his fist, yet also asserts that the defendant must have something heavy in his hand to break his skull and knock him out. Remember, there were no bruises on the defendant's knuckles, so a strike with the fist seems less likely, inconsistent with the victim's testimony. Let's see. At times, the victim claimed repeated blows by the defendant to his head, yet there was no evidence of any damage to the defendant's knuckles. The victim claims the defendant struck him with the shovel when he was already on the ground. He claims that he passed out, woke up, and the defendant struck him again with the shovel. These descriptions are candidly unbelievable and highly inconsistent with the other testimony. So here the court's making evaluations of credibility of testimony. The state argues that the wound on the victim's head was consistent with such striking, but the court disagrees. The medical evidence was that there was a heavy blow that sliced through both flesh and bone and laid open the brain. The photograph in the injury suggests that the slice was from the front, laterally from the right side of the head over the ear to the top of the skull. This path is highly consistent with the crossing, slicing motion described by the defendant. He admitted that he grabbed the shovel from the victim and swung it from his left to his right toward the victim as the victim attacker rushed towards him. The wound is consistent with the path. The force is consistent with his own admission and the medical testimony. The medical testimony is inconsistent with the victim's claims of multiple blows, including the mortal blow. Again, presumably they mean potentially mortal blow because the victim did not die from the blow. The court finds that it was objectively reasonable for the defendant to believe he was the subject of an aggravated battery. This would be the forcible felony condition for the use of deadly defensive force, and that would be objective reasonableness. Court continues, he subjectively believed his life was threatened, and particularly after he had been wounded 3 times by the actions of the victim. So we have objective reasonableness, subjective belief. That's the element of reasonableness. Remember, folks, if you don't know these 5 elements of self-defense law, I urge you to get this free infographic. It lists the 5 elements: innocence, imminence, proportionality, avoidance, and reasonableness. It's absolutely free. It's just a PDF download. You can get that at lawofselfdefense.com/elements. So he meets the conditions of the element of reasonableness according to the court, which finds subjective belief, genuine good faith subjective belief, that was objectively reasonable. It was also objectively reasonable for him to defend himself using deadly force. He had been subject to a forcible felony as defined by statute. He both objectively and subjectively believed that deadly force was necessary to defend himself, in particular after he disarmed the alleged victim and yet found himself the subject of further attack by the alleged victim. He had no obligation to retreat. That's the actual stand your ground provision of Florida, not all the self-defense immunity stuff. Simply being relieved of what would otherwise have been a legal duty to retreat, being relieved of that element of avoidance. That's what stand your ground means, and only that. That would be different, by the way, if he was on the victim's property. He might well have had a legal duty to retreat because he might arguably have been in a place he did not have the right to be, which is one of the conditions for stand your ground. And according to Florida courts, not by statute, but according to Florida courts, also a condition of self-defense immunity. The court continues. The court does not find that the defendant, was the aggressor whose duty to stand his ground was abrogated or lost. The state has the burden to prove that the defendant is not entitled to immunity, right? To prove it by clear and convincing evidence. The court continues, the state has failed to meet its burden of providing clear and convincing evidence that the defendant is not entitled to immunity. This was a tragic incident. The court is highly sympathetic to the condition of the victim, who presumably suffered permanent traumatic brain injury. The court cannot explain why his version of events is so different and has carefully considered the bias of the defendant and the other witnesses. Hearing the medical testimony, the victim is lucky to be alive. This does not change the balance the law imposes with the Stand Your Ground Act. Again, it's not Stand Your Ground Act. It's the Self-Defense Immunity Act. The state has the burden under that act. The facts are simply not in their favor. It is hereby ordered and adjudged the motion to dismiss under Florida Statute 776-012 is hereby granted. Now, it might be more accurate to say the motion to dismiss under Florida Statute 776-032 is granted. 776-032 is the self-defense immunity statute, but it says if you meet the conditions of self-defense, you're granted immunity, and the self-defense statute is 776-012, which is what's cited here. The case is dismissed. The defendant is released from bond and pretrial release conditions, and he is immunized under Florida law against both criminal prosecution and civil suit. And I would presume he was sued by the victim. I mean, the victim lived and suffered serious injury. Done and ordered on the 28th day of January 2022. And again, that was by Judge Howard O. McGillen. I'm not sure why they don't actually print his name. That would be nice. It's hard to read the signature. Can't really read the signature, but I looked up the name from other sources. So that's who it was, Judge Howard O. McGillen. And that is this case's self-defense immunity hearing, order, and finding on the facts and the law. So let me take a look now and see what we have in terms of questions. So first I'll turn to the law self-defense members questions. Let's see. Dave asks, you mentioned in this case that the defendant had a previous conviction related to the case. No, the defendant's previous conviction was a conviction of guilty of attempted manslaughter and aggravated battery with a deadly weapon on these facts of this victim. And that was overturned on the grounds of ineffective assistance of counsel. So he got a new trial on these same facts, this time on a charge of attempted murder and aggravated assault with a weapon. And while awaiting that new trial on these facts, he filed a motion for a self-defense immunity hearing, what this judge calls a stand your ground hearing, unfortunately, and was granted immunity as we discussed. Oscar, another law self-defense member, asks, how does a self-defense immunity decision, good or bad, impact subsequent decisions in other cases? Well, it really doesn't, folks. Even what happens had this gone to trial, what happened at the trial doesn't really affect other cases, at least not in the sense of having what we would call precedential value. So trial courts are bound by the decisions, the rulings of courts above them, higher in the hierarchy. So the mid-level appellate courts, the state supreme courts. What the appellate courts decide and rule is binding on the courts, the trial courts subordinate to them. And what the state supreme court decides is binding on the mid-level appellate courts below the Supreme Court, subordinate to the Supreme Court. So it all runs downhill, right? It's a pyramid. The peak of the pyramid is the state Supreme Court. Its rulings are binding on everybody. Below the state Supreme Court, there's a variety of mid-level appellate courts. Their rulings are generally not binding on each other, but they are binding on the trial courts subordinate to them. But there's nobody, for these purposes, there's nobody subordinate to the trial courts. There are town courts and traffic courts, but we're not talking about those. So trial courts don't have any authority over any other court. For all practical purposes. So what a trial judge decides in a particular case is not controlling on any other court, any other trial judge. It's not even controlling on that trial judge. I mean, I've seen cases where a judge made an evidentiary ruling in a criminal trial. The defendant was convicted, appeals his conviction. The conviction is reversed. So the defendant, the appellant, gets a new trial. Generally, when that happens, by the way, the new trial goes back to the original judge. So it did here. It goes back to the first trial judge. The same evidence came up, was disputed, and the second time the judge decided not to allow the evidence. So the fact that that judge had previously decided to allow the evidence and now was deciding not to allow the evidence shows you that his earlier ruling was not binding even on himself, even in the same case. So what trial courts do isn't binding on anybody. Certainly what a trial court decides in a pretrial hearing, like a self-defense immunity hearing, is not binding on anybody, for sure. Having said that, there are circumstances where there might be a legal question that's not been decided by the appellate courts, that maybe has not been previously considered by a particular trial judge. And that trial judge may decide to inform himself on what a prudent decision would be on that question by looking at what his colleagues have done in other trial courts. So either party might bring them up and say, Your Honor, we understand in your court this has not come up, but your colleague, fellow judge, Joe Smith, had this issue come up, and this is how he decided it. And another of your colleagues, Judge Sarah Maple, also had this issue come up, and she decided in the same way to deal with this issue. So we would argue that it would be most appropriate for you to also conduct yourself as these other trial judges have done. But that's entirely within the trial judge's discretion. He may decide he agrees with his colleagues and wants to do it that way, but it's up to him. So just like we saw in the Kyle Rittenhouse case, Judge Schroeder would not allow the people against whom Kyle had used force to be described as victims in the courtroom, because as far as he was concerned, we don't know yet whether they were victims of unlawful force, because we don't know if Rittenhouse was justified in his use of force. If Rittenhouse was justified, they were not victims. The other parties were not victims in any meaningful sense. Most courts don't feel that way. Most courts understand from a technical perspective that what we mean by victim is victim of the use of force, regardless of whether that use of force was justified or not. They were clearly victims of the use of force. And that's how lawyers are taught this stuff. When we learn this a little bit, we're taught on use of force law in law school, or when you read appellate court cases, at the appellate court level, they invariably describe those people as victims, just as this court did in this order here. So that's how judges are taught to talk about this kind of thing, and lawyers are taught to talk about this kind of thing. The person against whom the force was used is the victim of the use of force. We don't necessarily mean that that use of force was unjustified. So we're not misled when we use that terminology. But Judge Schroeder's concern in the trial of Rittenhouse was that while the court would understand this and the lawyers would understand this, that calling the person the victim doesn't mean that the use of force against them was unlawful, was criminal. The jury might not get that. The jury might be using the word victim in a colloquial sense, and presume that if everyone's calling these guys victims, that must mean that the defendant did something criminal. That's why Schroeder didn't like the use of the term victim in that Rittenhouse trial. We also just covered the trial of Theodore Edgecombe in the same, I believe it was the same courthouse, different judge. And that judge was fine with using the term victim for the person against whom the force was used. And frankly, that's the norm. That's more common than Bruce Schroeder's decision not to allow the use of the term victim. So my point here is what happened in the trial in Bruce Schroeder's courtroom in no way constrained the decisions of the judge in the Theodore Edgecombe courtroom, even though these are two judges who work as colleagues. They work in the same courthouse, I believe. They certainly know each other. And the judge in the Edgecombe trial was certainly aware that, he said so in court. He was fully aware that Bruce Schroeder had not allowed the use of the word victim, but his position was, this is my courtroom and I get to decide in my courtroom, and I decide that victim is allowed. So what happens here in this self-defense immunity order that we just covered is not binding on any other self-defense immunity hearing, but to the extent that it might be perceived or presented as a reasonable approach to making these decisions, Other judges might choose to look at it and say, yeah, that's a pretty good framework for determining self-defense immunity. And I'm going to be inclined to follow that similar framework, similar threshold, similar decision-making in my own self-defense immunity hearings. But that's not binding on them. That would just be a matter of their discretion. Skip, another law self-defense member, says Judge McGillen was apparently a candidate for Florida Supreme Court in 2002. No kidding. Well, that was quite a long time ago, 2002. That was 20 years ago. But certainly I enjoyed his order and would have enjoyed it had it gone the other way. It's quite well structured, reasoned, written in a very plain English style that's easy for anyone to understand, really. So I thought it was a great job. It will be interesting when we interview the defense attorney here, John Terhune, if to what extent this order reflects his own filings in the case, right? So he submitted a motion for the self-defense immunity trial, which is a written document, which might have been structured much along these lines. The state would have submitted its own motions, but sometimes to ease their workload, judges will sometimes more or less adopt the language of the party they agree with. So if the defense attorney provides a nice framework of argument and the judge happens to agree with the defense, the judge may just adopt that framework, say, hey, this is a good outline. I'm just going to work from this. Customize it, with my own words and such, but use this as a framework for my own decision. Of course, I haven't seen the motions in the case that were filed, but when we interview John, the defense attorney in this case, he'll be able to share that insight with us. Oh, Skip says, sorry, that was January 2020, not 2002. So only 2 years ago. Well, and we'll see what happens with Judge McGillen's career. All right, so those are all the questions from the law self-defense members. Let me now turn to the super chat questions. And thank you, of course, all for joining me. I know it's been 2 hours. I've been talking for 2 hours, and we still have about 500 people here, so that's nice. Dennis, thank you for your super chat contribution. Thoughts on a taser for EDC, everyday carry, or for self-defense? So I'm not a fan of tasers for individual personal protection purposes, for EDC personal protection purposes, for a number of reasons. And again, my expertise is use of force law. It's not defensive tactics. So I want to put that in context. But I'm exposed, because of my work, to a lot of cases involving the use of tasers. And to my mind, where tasers are most useful is in a context where, frankly, the use for deadly defensive force is probably justified. But the police feel that they may have the luxury of first trying a lesser degree of force, a degree of force not likely to cause death or serious bodily injury, a less than lethal use of force, which a taser is. And so they'll try to tase that suspect in many cases where the suspect probably could have been lawfully shot. But they don't want to shoot people they don't have to shoot, so they'll try the taser first. The difficulty is tasers, when they work well, are amazing. But they so often don't work well. They so often don't work at all. And either because, there's so many ways, even when they're used properly and the person they're being used on does not know how to defend against a taser. And there are ways to defend against a taser. But even when they're used properly and there's no defense, often you don't get good strikes with the probes. They don't go where they're supposed to. You don't get enough spread, or they fall out, or it's a sufficiently dynamic encounter that the person against whom they're used manages to rip out the probes or the cables. And the moment the juice stops running, the effect is done. So it's not like, you shoot someone, they have a gunshot wound that's still affecting them after the shot is fired. With the taser, once the current stops, there's no longer a debilitating effect. Also, they're not that hard to defend against. I mean, if someone's wearing like a big sports jersey, for example, and they just put their hands under the fabric and spread the fabric out in front of them, that's an effective defense against a taser. And lots of people who might be subject to tasers know that kind of thing. So tasers fail to work as desired a shockingly high percentage of the time. Now, when they're used in the scenario I described, where you have a suspect who probably could be lawfully shot, but the police feel they have the luxury of attempting less than lethal. What you'll typically see is one officer with the taser in hand, not doing a quick draw for the taser like the Kim Potter case, but having the time, the luxury to deploy the taser in a deliberate way. So they have a taser in hand. They are backed up by one or more officers with guns in their hands, so that if the taser doesn't work and the situation does go lethal, there's immediate, instant, deadly defensive force backup. And that can work for police, but most civilians, most individuals don't have that luxury. They don't have a second person with them to back them up with deadly defensive force. So if the taser fails to work, that's it. And if they're facing if that escalates to a deadly force encounter, do they have a deadly force option? I don't know. Now, having said that, are there circumstances in which a private citizen use of a taser might be a good choice in the moment? Sure, I guess so. I just think there's better. I think there's better options. I think pepper spray, OC spray is typically a better option for most people. Again, I don't tell people what to do, so I'm not telling you not to use a taser for self-defense. If your circumstances better than me, if it fits your circumstances and whatever the legal framework is in your jurisdiction, that not every jurisdiction allows for the possession of tasers, for example. But if you think it's a good idea for you and it's lawful, then by all means do what you think is best. But you asked my thoughts, and those are my thoughts on private citizen use of tasers. By the way, of course, obviously I carry a gun for personal protection. I have my entire adult life. My primary non-deadly force fallback, if I have to defend myself against a non-deadly force attack, is pepper spray. If I have my gun on me, I also have my pepper spray on me. I always have both. But if I couldn't have a gun, if I lived someplace like I've lived previously in my life, jurisdictions where a concealed carry permit, lawful concealed carry of a gun was practically not possible, then carrying something like a taser would become much more attractive. Maybe. I'd have to think it through. Let's see. Another super chat. Thank you. Anomic. Very interesting names. Writes, we never locked our doors on your advice. We do now. Would a locked gate on a rural property make a difference? We are very rural, 1/2 mile driveway. So this whole locking your doors idea, it's really independent of this self-defense immunity order that was at the heart of today's show. Comes around from the defensive castle scenario. So there's really kind of three buckets for lawful use of force. One is defense of persons, yourself or some other person. The other is on the other extreme, we have defense of mere personal property, items, for example, your unoccupied car, unfortunately, your pets. Mere personal property almost invariably can only be defended with non-deadly force. You can't use deadly force to protect mere personal property. Yes, there is one exception, Texas Penal Code 9.42. You can find it at Texas. Find it at lawofselfdefense.com/942. But for all practical purposes, let's presume for our discussion, mere personal property, only non-deadly force. But what about stuff that's not mere personal property? It's highly defensible property. So you're still not defending a person. You're defending highly defensible property, which always includes your home, may include a place of business, may include an occupied vehicle, and that varies by state. And many states will differentiate between defense of highly defensible property, like your home, from defense of mere personal property, not by making it lawful for you to kill over the physical structure of your home. That's not what these special provisions do. What they do is they, in effect, allow the highly defensible property to act as a surrogate for the people inside the property. So you're not literally being permitted to use more defensive force to protect the shingles on your house or the doorknob on your door. What's happening is the law is saying, hey, because the attack is happening on highly defensible property, like your home, on property, a key purpose of which is the shelter and protection of the people inside that property, we're going to treat that differently than if someone was stealing your briefcase, for example. We're going to create a legal presumption that the person attacking that highly defensible property that you have, we're going to legally presume that you have a reasonable perception of an imminent deadly force threat, deadly force attack. And what that legal presumption is doing for you folks is, I mentioned earlier, there's 5 elements of a claim of self-defense, up to 5. Innocence, imminence, proportionality, avoidance, and reasonableness. Again, you can get this free infographic at lawofselfdefense.com/elements. I urge you to do that. What that legal presumption is doing is giving you most of these elements. It's saying if you're dealing with an attack on your highly defensible property, on your castle, we'll legally presume that you're facing an imminent, that you have a reasonable perception of an imminent, unlawful, deadly force threat. And that's giving you the elements of imminence. It's giving you the element of reasonableness. It's giving you the element of proportionality. You're already relieved of the element of avoidance in your castle because of the castle doctrine. The only element not given you, not presumed to exist, is innocence, but that's kind of baked in the cake if you're dealing with an attack on your home. But this legal presumption that basically gives you everything you need to justify your use of deadly defensive force against that person does have conditions. And often the conditions are that that person against whom you're using force either has entered or is attempting to enter your highly defensible property unlawfully. So they're not like a co-dweller. They're not cops serving a warrant, a search warrant on the house. They've entered or attempting to enter unlawfully and forcibly. And the reason the legislature often, almost always, adds that forcibly component is they're worried about the prospect of the innocent intruder, someone who's unlawfully present but without malice. And if you're wondering how that could happen, well, it happens all the time. Repairmen are sent to the wrong address. They're saying, hey, these people need their dishwasher fixed. They can't stay home, but they're going to leave the back door unlocked so you can get in, fix the dishwasher. And then they give the repairman the wrong address. And the repairman goes to the wrong home. Sure enough, the back door is unlocked. He walks in. He's not in the right place. Those homeowners did not give the repairman permission to come in. He's there without license. He's unlawfully present. But he didn't forcibly enter. He didn't break something to get in. And the legislature does not want this legal presumption of a reasonable perception of an imminent deadly force threat to apply to that repairman who's unlawfully present but without malice. And we know there's no malice because he didn't break anything to come in. Because if someone didn't break something to come in, they may be an innocent intruder, right? Unlawfully present without malice. But if they broke something to get in, that option's off the table, right? There is no innocent explanation for why he kicked the door in to repair your dishwasher. That's not a thing. So often it's required that to get the benefit of this legal presumption that the entry, the intrusion, has to be both unlawful and forcible. And because of that forcible component, I often urge people to keep your doors locked. Make sure that if someone's going to be an intruder in your home, that they can't be an innocent intruder, that they had to break something to get in. And you don't need a lot. It could just be a screen door with a little hook latch. If anything is broken to get in, it was a forcible entry. Meets the requirements for this legal presumption. But if nothing was broken to get in, it could be an innocent intruder. So certainly within the 4 walls of your home, and generally this legal presumption only applies to an intruder into your home or something attempting to intrude into your home. So for your home, keep your doors locked. So if someone comes in, they have to break something. That removes all ambiguity from that situation and almost certainly qualifies you for that legal presumption. Now, the legal presumption also has a lot of exclusions, too complicated to go into today. I would urge you to get our course, lawselfdefense.com/bundle gets you our 4 best-selling courses, saves you a fortune on the cost of those courses. We're still running that sale now. You can get that at lawofselfdefense.com/bundle, or get the hard copy of our book at lawofselfdefense.com/gethard. All hard copies, by the way, are personally autographed by me, if that matters to you. I never see the soft covers before they go out of the warehouse, but the hard copies, I sign every one of those myself. So here, Anomic is saying, hey, we never locked our doors before, but on your advice, we do now for all the reasons I just explained. What about a locked gate on a rural property? And I actually had a friend of mine quite famous person, so I won't name them, of course. But they had an issue with intruders on their property, sizable piece of property. And my advice to them, and people were just driving into the property because they were famous. It was very uncomfortable. But my advice to him was, put a gate at the end of your driveway, because of course, people can drive through a gate or maybe even around a gate. But if they've gone through the gate, that removes all ambiguity about that situation. Now, that wouldn't necessarily qualify you for the legal presumption we've been talking about, because usually open property, it's treated differently than inside the four walls of your house. Especially the further away from your home that gate is, it's probably not even within the curtilage of your home. The area immediately around your home, that's part of the normal day-to-day function of the home, that is often treated as if it were inside the four walls of your house, especially for castle doctrine purposes. But at the very least, the person can't be there by accident if they had to go through a gate in order to get there. So, if that's a concern, unexpected strangers showing up at your house, and you'd like to remove ambiguity, I'd put a gate and a sign up, and then at least there's no question that they're there by accident. Let's see. I see lots of questions, folks, but I only have time to answer the super chat one. So if you feel strongly that you'd like your question answered, that would be the way to do that. Do it as a super chat. And I'm scrolling. Sorry, I know that other people who do this streaming stuff. Let's see. Okay, so Coy 540, thank you for your super chat. Coy asks, if I have a friend I want to buy one of your self-defense classes for, and preempt questions like, why did you buy legal self-defense training for yourself? Did you expect to kill? How can I do that? How can you preempt those questions? So this often comes up in the context really of any self-defense course, right? Why did you get a concealed carry permit? Why did you take a shooting course? Why did you train in martial arts? Why did you go to a law self-defense course? Is it because you were planning to kill somebody? Can a prosecutor ask those kinds of questions? Can they use that kind of thing, that training, quote unquote, against you in court? Anytime someone asks, can this be used against me in court? If by against me in court, we mean, can a prosecutor talk about this in front of the jury in an effort to make me look bad? The answer is always yes. There's really no limit on what a prosecutor can talk about. Can a prosecutor try to argue that the only reason you got a concealed carry permit was so you could kill somebody? Yes, they can make that argument. Famously, in the George Zimmerman trial, the prosecutor screamed to the jury about the fact that not only did George Zimmerman have a 9mm pistol on him, he was carrying it with a round in the chamber in the ready-to-kill position or condition. It's a ridiculous argument. Every bailiff in that courtroom, armed bailiff, sheriff's deputy, had a round in the chamber of their service pistol. Does that mean they're imminently about to unlawfully kill somebody? Of course not. So the real question is not whether or not a prosecutor can talk about such things in court, because they can talk about anything. The real question is it likely to harm you? Is it likely to get traction with the jury in a negative way? And how easy would it be for your defense counsel to mitigate that risk? And frankly, the kind of training you might get that's least likely to be harmful to you would be legal training, like you get at law self-defense, because guess who else in that courtroom got legal training? Everybody. Clearly the judge did, clearly the prosecutor did, clearly the defense attorneys did, and clearly the jury will, because they'll get jury instructions, which is legal training on what the law is and how they should apply it to the facts of the case. So everyone got legal training, even just in the courtroom. So it's certainly hard to see how an otherwise valid claim of self-defense would be damaged by the fact that you informed yourself on what self-defense actually is. And really, that applies also to any legitimate form of self-defense training. Can a prosecutor talk about the fact that you went to Gunsight or wherever and got self-defense training? Yeah, sure. He can bring that up in court. Is it likely to be damaging that you learned how to defend yourself? I don't see that. I mean, now you wouldn't want to go to Gunsight, obviously, is for those who don't know, is a very reputable shooting school. There are some crazy instructors out there. There are some instructors that say crazy things and teach crazy things. I'm not sure I'd go to one of those places because, if you go to the kill them all and let God sort them out shooting school, that could look bad. Sure. That might get traction with the jury because why you chose to go there? Why? Is that your view of the world? You're above the law. You're a vigilante. You went to the Punisher School of Executing Criminals, Vigilante Academy. I wouldn't go to places like that. But if you're going to get reputable training, I wouldn't be concerned about it. Can a prosecutor talk about it? You should assume yes. I mean, of course, your defense lawyer will object, and the judge might hopefully would sustain that objection because it's not really relevant to any of the legal issues in the case. But you have to assume the worst case scenario. Assume the prosecutor brings it up. Your defense lawyer doesn't object, or he objects and the judge overrules the objection and the jury gets to hear it. How damaging is it likely to be, and how easy is it to mitigate the damage? I expect if you went to reputable places, not very damaging and not hard to mitigate. So that would be my answer to that question. Oh, I see a lot of people are mentioning their books have arrived. Yes, I'm sorry for the delay, folks. We had a lot of books in the warehouse, and you bought them all. So we had to get more printed up. But I'm told that we're within a few days of we may already be completely caught up now. So hopefully all of you got your books, but if not, or we're within only a couple of days of having that all caught up. Our new books have definitely arrived at the warehouse and are being shipped out as rapidly as our guys can do it. By the way, folks, when we say you can get a copy of our book for free, and you can, the soft cover at lawselfdefense.com/free book, but we ask you to pay for shipping and handling. That's who you're paying for, folks. You're paying for the guys in the warehouse who pack up those books, put the shipping label on them, make sure it's all done correctly, make sure it gets done in as timely a manner as inventory allows. Those guys all get paid. They all have mortgages. They all have families to raise. They're entitled to be compensated for their efforts. That's what the shipping and handling pays for. Those dudes in the warehouse who do a great job for us. Jonas Anderson asks, and thank you for that super chat, Jonas. The objectively, subjectively criteria seems a bit superfluous. Could you make a case where self-defense is objectively but not subjectively reasonable? Yeah, for sure. Usually it goes the other way. Usually there's subjective belief is present. If you put the defendant on a magical lie detector that actually worked and asked them, were you justified in acting in self-defense? They'll say yes, and the machine will say they're telling the truth. That's their genuine subjective belief that they were privileged to use force in self-defense. They think they acted in self-defense. But circumstances are such that it's not, their belief is not objectively reasonable. They got scared, their fear was irrational, and so forth. That's the norm. So the norm is you'll find where someone fails on reasonableness, they don't tend to fail on the subjective component. They tend to fail on the objective component. But the reverse can happen. There can be circumstances, and there are cases in which there's an attack that would be objectively perceived as being an imminent, unlawful, deadly force attack upon the defender, but there's no subjective fear. And how do we know there's no subjective fear? Because obviously subjective state of mind is inside a person's head, right? We can't see inside a person's head. We can't see their thoughts. Well, we evaluate that how we always evaluate intent, from the circumstantial evidence and from often their own statements. So sometimes you'll have a defender who'll tell the police or others after the fact that, they were never really afraid of that person. Well, if they were never actually afraid of that person, there was no subjective, genuine, good faith belief in the need to act in self-defense, right? Or maybe the event was caught on surveillance camera and the person claiming self-defense is seen closing on the other party as opposed to trying to get away. Well, normally people don't get closer to things they genuinely believe are likely to kill them. They try to get further away from those things. So that would be circumstantial evidence of a lack of a genuine good faith, subjective belief that you were facing a deadly force threat. So that's how those arguments would appear in court. All right, scrolling. Let's see. Gremlinton, thank you for your super chat. He asks, how can we get the NFA repealed? I want to be able to own a full auto without spending my life savings and going through miles of government tape. Brother, when you figure it out, let me know and you'll have my full support. The NFA is the National Firearms Act. It makes lots of things like fully automatic firearms, suppressors, firearms with a caliber greater than, I think it's half an inch, all kinds of stuff. Not necessarily per se unlawful, but requiring the paying of a tax stamp and a bunch of hoops that have to be jumped through with the federal government, and maybe unlawful by state law in many states. So it's obviously an infringement on the right to keep and bear arms. It's facially unconstitutional. It ought to be repealed. I'd be happy to see it repealed, but I'm just a small town lawyer in Colorado, folks. So you'll need to talk to politicians about that. Linda Baldwin, thank you for your very generous super chat. So she got her free book, and her super chat is a multiple of what it would have cost her to buy the book. So that's very kind of you, Linda. She says, thank you for the very interesting presentation. Thank you for my free book. I wanted to pay it forward. Well, that's much appreciated, Linda. She didn't even have a question. She just wanted to say thank you. Okay, scrolling. Man, we still have 450 people here. Let's see. All right. I'll see if there's any more member questions. And then one last, let's see. Oh, there are. Okay. Dave, a law self-defense member, says, you mentioned during this discussion that the defendant's concern about having the shovel wrested away from him by the victim was a legitimate part of his use of the shovel in self-defense. So you'll remember, folks, the facts in this case were that the victim here, by victim we mean the victim of the ultimate use of force, was the defendant argues the victim was actually the initial aggressor. The victim had a shovel, attacked the defendant with the shovel, and then the defendant managed to strip the shovel away from the victim. Now, arguably, at that point, the victim was no longer a deadly force threat. He no longer had the shovel. He did continue his assault, but it was a barehanded assault. And of course, the defense argument would be, sure, I had seized the shovel, but he was continuing to attack me, and therefore I had a reasonable perception that he was going to take the shovel again from me and use it again to attack me with deadly force. Dave asks, are there any good cases that demonstrate this argument where an armed offender successfully used this fear of being disarmed in their argument for legal self-defense? Yeah, thousands of them. Almost every police self-defense scenario in which there's a struggle with a suspect involves this. The suspect begins to go for the cop's gun. So the cop has to draw his gun and basically shoot the suspect off his gun. Happens all the time. In the George Zimmerman case, one of the arguments of self-defense for George Zimmerman was, not only was George Zimmerman having his head pounded against the sidewalk, which clearly is an infliction of force readily capable of causing death or serious bodily harm. We had expert medical testimony at the Zimmerman trial that having your head pounded on a sidewalk is likely to cause serious bodily harm, if not death, from a cranial bleed. Not only was that happening while George Zimmerman was on his back, mounted by the attacking Trayvon Martin, but then Zimmerman testified, and there was no counter testimony, that his jacket fell open. Trayvon Martin saw Zimmerman's holstered pistol, threatened to then kill Zimmerman effectively with the gun, and then went for the gun. And that's when Zimmerman drew his pistol and shot Trayvon Martin once in the chest with a 9mm Kel-Tec. And arguably, it was partly to prevent Trayvon Martin from his apparent intent of seizing Zimmerman's gun, which, folks, is no different. When someone's trying to take your gun, that's no different than if they were reaching for a gun on a table, right? It's actually worse, because not only are they arming themselves, but they're simultaneously disarming you. What you have to be careful of is circumstances in which this perception of the other party taking your gun is speculative. Well, for all I knew, he might have gone for my gun. That's not a compelling argument. If there's actually a physical struggle and you can articulate an evidence-based fear of the other party actually going for your gun, that's one thing. But you can't just presume or speculate that they're going to go for your gun. And that's why you shot them now. Let's see. Lots of Zimmerman misinformation on here. This is not a super chat, but someone named Michael Palmer says that Zimmerman was following the guy with the loaded gun. He didn't own the neighborhood, and I don't think he had any business following him like that either. Should have called the cops. Well, he did call the cops. He was on the phone with the cops. And then Trayvon Martin ran, and the dispatcher asked Zimmerman. Trayvon Martin ran behind the building. The dispatcher asked Zimmerman to identify where Trayvon had run to, and Zimmerman got out of his car to answer the dispatcher's question. When the dispatcher said, "We don't need you to follow him," Zimmerman said, "Okay." So there's no evidence that Zimmerman did anything other than act consistent with the dispatcher's request for additional information. And when informed explicitly that the officer didn't need, or the dispatcher didn't need Zimmerman to follow suspect Trayvon Martin, Zimmerman was completely compliant with that request. So, it's if you inform yourself on what the facts of the case actually are, you're much less likely to come across as ill-informed and ignorant about the case in question. Okay. All right. I think I've answered everything, folks. So with that, it's been 2.5 hours. Still over 400 people here. I can hardly believe it, but I hope you enjoyed the show. Let me give you a quick mention on what we'll be covering for the rest of the week. So tomorrow, we're doing something very unusual. In fact, the first time we've ever done it. We're going to have a guest on the Law Self-Defense program. That guest is going to be attorney Derek DeBras out of Ohio. As you know, my own expertise is use of force law, not gun law. I don't do gun law. But Derek DeBras is an attorney with a great amount of expertise in gun law. And I had received a question from a Law Self-Defense member, actually a letter, a physical letter in the mail from a Law Self-Defense member asking me about gun trusts. Gun trust, a trust is a artificial legal entity that's created. For legal purposes, it's treated as if it were a person. And it's possible to set up a trust for the purpose of owning guns. So you're not the owner of the gun. The trust is the owner of the gun. And many people like to set up gun trusts for these NFA type items we just talked about. Things like fully automatic weapons, suppressors. Because if you own those things yourself and you die, it can be very complicated for your family to, well, technically, they're not legally permitted to possess those items. They didn't go through the process with the federal government. You did. Your possession is lawful, but now they're in unlawful possession of a machine gun, right? Or a suppressor or whatever. If you set up a trust, and this is just my understanding, so Derek is going to give us all the details tomorrow. The idea is if you set up a gun trust, the gun trust owns these items. And if you die, it's still the gun trust that owns them. Much easier for your family to sell these items, or I guess if they're also members of the trust, to remain in possession of the items. So that's the idea behind the gun trust, as I understand it. Again, I claim no expertise, but attorney Derek DeBras will join us tomorrow at, I believe it's 2 p.m. Eastern time, so noon Mountain time, my time. So a bit later than we did today's show, than our normal show. But we had to accommodate Derek's schedule. Attorney Derek DeBras will be on the show to discuss gun trust with us in detail. So not a use of force show, a gun law show, but I know many of you are wondering about it. Frankly, I've been meaning to set up a gun trust myself for quite some time, just haven't gotten around to it. So this may be the catalyst I need to finally get my butt in gear. And Derek DeBras will explain to us how all of that works. That's tomorrow. Then on Thursday, we're back at our normal time, 9 a.m., and we're going to cover a very interesting case that recently was brought to my attention about, well, addressing the question of whether your homeowner's insurance can cover you against legal liability if you use defensive force in the context of your home. So you use defensive force against an intruder in your home or a guest in your home or whatever the case might be. Will your homeowner's insurance cover your legal expenses? And there's a lot of different answers to that, depending on what state you're in and what insurance you have. But this case gives us opportunity to explore those issues. We're going to cover that on Thursday's show at 9 a.m. So that's already pending, I guess, on our YouTube channel. So you'll want to click the little reminder button also for Derek's show tomorrow to make sure that YouTube reminds you about that. If you're a Law Self-Defense member, you'll find it on your member dashboard. That's where, as it worked today. So I think we finally have that part working as well. Let's see. Oh, there's C. Goody 564, an admin for Nick Ricotta. Thank you, C. Goody. That's much appreciated. Welcome. Okay. Well, I think we've covered it all, folks. So until tomorrow, I will say, oh, for those who are asking, Mrs. Branca, my wife, Emily, she was diagnosed with breast cancer last year, has had surgery and all the necessary treatments. We were very lucky. We caught it early. It looks like it's all wrapped up as positively as anyone could expect. She's recovering beautifully. So everything is gold on that front. But thank you for your concern and for your prayers. That's been much appreciated. All right, folks, remember, until we meet again, hopefully tomorrow for the Attorney Derek DeBras show at 2 p.m. Eastern time. If you carry a gun, so you're hard to kill. That's why I carry a gun. In fact, got a new gun for that purpose this Christmas. If you carry a gun, so you're hard to kill, you also owe it to yourself and to your family to make sure you know the law so you're hard to convict. Not through legal tricks. We don't teach legal tricks, but by knowing the law of self-defense, as you might learn it from our best-selling book, hardcover, autographed by me, lawofselfdefense.com/gethard. All right, folks. Hope to see a bunch of you tomorrow. Tell your friends and family, hit like and subscribe, all that nonsense, and we'll meet again soon.